Good evening, good evening, good evening. It is an extra special ride. It is Monday, July 8th, and we had an emergency. So there was much need to stream. So this is an emergency stream. It is a we will ride. It has been a very busy couple of days for me, and I know all of you know how long this trial was. Like it wasn't just long, it felt long because 9 weeks of trial. And then we have more gavel to gavel coverage starting this week with the Alec Baldwin case. I had lost my voice. I had also been at VidCon and concerts, and then 4th of July and family. And that is what kept me a little delayed this evening was family stuff. So I appreciate all of you understanding. I was not supposed to be streaming today. I was not really planning on streaming tomorrow. I was just going to start with opening statements in the Baldwin case, but there's no chill. There's just no chill. Nothing has any chill. So, because the world has no chill, it's the most Monday ever. Let me know where you're coming in from, what you're drinking. I have tea because it feels like that's the appropriate thing to do. And I am still working on recovering the voice. So, thank you all for your patience. And I haven't even had a chance to text a friend who hooked me up with their doctor here in Nashville. And I will, after stream, be texting. But if you are watching, thank you so much. It has been fantastic. I was up in Nashville today and last week. So that has been needed and great. So, with all of that, we are going to dive into all of this. Do y'all want to know what we're talking about tonight? Y'all already know what we're talking about tonight. Y'all already know what we're talking about tonight. You know why? Because you guys set up the freaking EDB bat signal with a freaking swiftness. The law nerds will not be denied. And I put in our app and I put in our spaces, hey guys, this is what's happening today. The defense in the Karen Reed case has filed a motion to dismiss. And all of you went, I know you say you're going to stream tomorrow, but are you sure about that? How sure are you that tomorrow is what we're going to do? How about no, we do that today? And then I went, yeah, you're right. Yeah, you're right. Yeah, you're right. We're just going to do it today. So after all the things that needed to get done in my world, I was like, you know what? You're right. We'll just do it tonight. We'll just do it tonight. And then the podcast will be late this week, and that's just going to be fine because are any of you mad that the podcast is going to come out a day late this week? No, none of you mind. All of you are like, no. We need to do this tonight, record the podcast tomorrow. So we're just going to swap. So members, we'll record the podcast tomorrow. We'll just do it tomorrow. We'll edit it. It'll come out on Thursday. What's a day? No, the podcast is fine. We need to stream. What we need to do is stream. There is no chill. We just have to stream. So today we are talking about the Karen Reed trial because this trial has no chill. I absolutely feel the anxiousness of all of you and like, what are we doing? What is happening? When do we ride? And it's been a minute. It's been a minute since we've had an emergency ride. So when those of you that were like, girl, when do we ride? Not only do I know you are the OGs, because you are the OG of the OGs, but you were like, when do we ride? And I'm like, you're right. How do we wait? How do we wait till tomorrow? And how do I sit down and record a podcast knowing that this is the only thing I want to talk about? And tomorrow on the podcast, we need to talk about everything that's been happening in the Baldwin case, because that case is getting ready to pick a jury and the attorneys are already buck wild as they will do. But we had to do this first. So we're gonna do a little bit of an intro, and then we are going to do this. So we are absolutely going to ride. We have got to talk. I've got tea. This motion has tea. And we need to talk about the emotional side of this, because there's a lot of like, seriously, WTF? Like seriously WTF? And then we need to talk about like the legal side of this, what the prosecution's going to argue, because of course we haven't heard from them yet. We will. Don't worry. We are at the beginning. of a process. So all of you just take a breath with me. Just breathe it in, breathe it out. We're not going to have answers swiftly for all of you that feel unresolved by this case. Correct. It was a hung jury. It is by its nature unresolved. So we are at the beginning of a process. We are not at the beginning of answers, right? So just process. This is law is a process. The law is a process. We're unresolved. We're going to keep being a little unresolved, but at least we'll understand what we're unresolved about after this. Maybe not. When we get to Q&A, you'll have to let me know. So with all of that, law nerds, I heard you. Thank you for sending out the We Ride EDB signal. I hear you. I hear you. I got DMs, comments, text messages from friends who are like, do we ride? Like, I have questions too. Yes, my friends are now like, what are we talking about? Are we riding? Emails. The team got emails to every email address you can find. And we're like, we heard you. You law nerds, you have been heard. Let's roll. We're gonna do a road so far. We're gonna go into court real quick because we need to do that. Yes, I had to rescue my nail bed that almost ripped off today. That was part of my day today. It's a story for later. But if you see the one janktified nail, I have preserved my nail bed, so that's good. The rest of it, very, very uncomfortable. A rare occurrence. But when you see me looking unbalanced with the nails that are normally great, the team had to listen. We were working on the app today. So we were working on the app today. That was one of the things that was going on with Team Baker. We had lots to do. But we also have to stream, right? So we're going to do a road so far. We're going to go into live court. We're going to take a look at what happened when the mistrial was declared. We're going to get into this motion to dismiss and the info from the jurors. The jurors. We're going to talk about that too. And we're going to talk about, I didn't get to tell you about my experiences with hung juries. I've had some experience with this happening in my own cases because the Wi-Fi would not let me be great, or the universe didn't want me to miss my flight home on Monday when all this went down. One of the two. You can pick whichever one you want to pick, just pick it. Either or. Wi-Fi not letting me be great, me not wanting to miss my flight. The way I scooted into the airport, right, in Milwaukee with like much time. But you know what? The airport in Milwaukee is a delight. And so having amount of time to get on my flight was all that was needed. Everybody was like, hey, how's it going? How are you doing? I'm like, good. Where are the rest of the people? They're like, it's okay. It's all right. There's just the three. There's just the three of you in line. It's going to be fine. I'm like, do I need to take this off for TSA pre-check? He's like, no, I just want to see your Metallica shirt. I was like, amazing. Here's my Metallica shirt. They're like, girl, you're all good. Just take a breath. You're all good. And I was like, this is amazing. I'm like, I apologize for my LAX trauma, but LAX was my home airport for a long time and I have lots of trauma. But Milwaukee, the Verizon not happening at all. But the airport, so chill. Flight home on Monday, so chill. Tons of Wi-Fi? No, but that's okay. And we got home. We made it to the right states. I got to hear Dave sing Halloween. All of it's good. All of it's good. And now we're here and we're going to start a trial. And though I have some, family stuff, it's all going to be fine. I'm not traveling. I'm not traveling during this trial. 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 I don't think we've done a trial that I haven't had to travel during in a minute. So we are not, knock on wood, we are not traveling during this trial. Let's roll the intro. Let's do a road so far. Law nerds, let's take a deep breath. Let's take a deep breath because, woo, boy, this is a lot. This is a lot.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
Do I have my screen ready to share? No. Is it being fussy with me? Yes. Are we back to the only fan in just a moment? Are we going to live? Oh, let me do the road so far first. Are we going to live court? Yes. Okay, road so far. Here's where we're at. All right, let's 9 weeks of trial in the Karen Reed case. 75 total witnesses. 5 days of jury deliberation. And on July 1st, the jury came back and said that they were hopelessly deadlocked. They could not reach a verdict or verdicts. Karen Reed was charged with 3 counts. Count 1 was elevated and added later by grand jury, but count 1 was that second-degree intentional homicide. Count 2 was the operating a vehicle while intoxicated or operating under the influence, with all of those added subparts, all of those lesser included crimes. And count 3 was the hit and run causing death, the leaving the scene of an accident causing death. Those were the 3 counts. The jury could come back on all, on some, on none. The judge swiftly declared a mistrial. It was very confusing to me at the time. It remains confusing to me that the judge did not poll the jury. Have I ever seen a judge do that? No. No. I've never seen the judge in a undetermined verdict, in a hung jury. I've never seen the judge not poll the jury individually. And you've seen this. You've watched trials with me. You've seen this. And when we've seen this, we've seen even with a guilty verdict, do you want to poll the jury? Yes. And they go through the jurors. Juror number 1, is this your verdict? Yes. Juror number 2, is this your verdict? Yes. And they go down the row. I've seen cases where they've gone down the row and a juror's been like, no, that's not my verdict. And it's like, you can hear the record scratch in the courtroom and everybody goes, wait, what? Wait, what? Wait, what? I've seen juries be polled and have to go back to deliberate because one juror is like, that's not what I agreed to. But I have never seen a undetermined jury not be polled ever. And the attorneys didn't ask for it in this case, and we're going to look at that now. But the judge very swiftly read the note and declared a mistrial. And it's like, once that mistrial is declared, this is all going to be hard to undo. But where are we at now? Well, Monday morning, a week after this jury was undecided and the court declared a mistrial, the defense filed a motion saying immediately the jurors started reaching out to them, and that those jurors indicated that they did have some verdicts, just not all verdicts. Can a jury come back with a split verdict? Yeah, they can. They can come back with a split verdict. They can come back with, a verdict on count 1 and count 3 and no verdict on count 2. They could have come back with a verdict on count 2 and hung as to the lesser included. There's a lot of options that could have happened here. But this is going to be difficult to unwind. So in what's going to happen next, we're going to have to talk about it, but this is going to be difficult to unwind. So with all of that, we're going to go to court. We're going to take a look at what happened on July 1st when the court read in the jury note. What we're going to hear from the defense in their motion is that the defense didn't know what this note said, which is also surprising to me, because normally when there's a note from the jury, the attorneys are alerted as to what the note is. And normally there's some discussion with the attorneys about what they're doing. And that seemed to happen with the other notes, because with the other notes, you saw some conversation between the judge and the attorneys before the jury came out. And even to the point where you saw Yannetti at one point arguing that the judge should give the essentially the Allen charge. In this case, it is called a Tui Rodriguez instruction, but essentially it's that, okay, guys, go back and really, really try hard this time. That instruction, you saw them arguing about it before they brought the jury out to address them. But in this motion, the defense says that they did not have that opportunity before this all happened. So we're going to watch this. We might need to go back and watch this again after the defense motion, but it's so quick that I think that's fine. So we might need to do this twice. That's all right. So we're going to go to court. We're going to take a look at, back to the OnlyFan for a moment. Back to the OnlyFan for just a moment. We're going to go back to the OnlyFan for just a moment, and then we are going to go through the defense motion. We're going to talk about what the options are. And we know what the defense wants here. I don't know if they're going to get what they want, but there's got to be some room for in the interest of justice here as well. So I think there's some things the prosecution's going to be real happy with in the defense motion. I think there's some things the prosecution's going to be real unhappy with in the defense motion. And we're going to talk about all of that too. So are you guys ready to ride? Let's ride. I think I have the sound. I think I have the sound gained up. It looks like I do. I meant to. So let's go to court. This is, by the way, this is July. What we are watching is July 1st in court. It is the last jury note that comes in, and it is the subject of a lot of this motion. So we're going to go through it before we get into this motion.
Thank you. Be seated. Closing session.
22-117 Commonwealth versus Karen Reed.
All right, the jury is at an impasse. So we'll bring them in.
That's it. The jury is at an impasse and we will bring them in. That's what the court says. The court does not ask to hear anything from the attorneys. It's clear to me in this moment, and when I was streaming, it was clear to me in this moment that she was going to declare a mistrial. The defense says nothing. The prosecution says nothing. But it's clear to me, it's clear to everyone that that's what's happening. This was clear. This was very clear to me. It's like, oh, she's declaring a mistrial. Okay, the jury's at an impasse. It was clear that that was the only thing that was about to happen here. And then the jury was coming in. No one said a thing at all. And I've seen, Shazam, thank you so much for the gift of memberships of 10 and 5. Welcome to all our new members. And I've seen a number of you say in Massachusetts, they don't poll the jury. They can if the attorneys ask for it. And the attorneys didn't ask for
All
it.
right, Mr. Foreman, I am in receipt of your note.
So it can be
Judge
done.
Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt.
She said charges, not charge. Charges. I don't think that is an error on the part of the jury. So keep that in mind. Keep that in mind. They say charges, plural here, very
Judge
clearly.
Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort
Twice. Charges.
or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service.
That's it.
Okay.
All rise to the court, please.
That's all. That's it. I'm declaring a mistrial in this case. Boom. Done. Nothing from the attorneys, no statement from the attorneys, no objection from the attorneys. No, Your Honor, wait, what the fuck? Excuse me, Your Honor. Aren't we going to poll the jury? Nothing. So the attorneys don't seem put off by what's happening here. And they say nothing here.
All right. I'd like to pick a status date to find out what our next move is. So I'd like to come back sometime, maybe the end of July.
And Yannetti's probably looking at his
I
calendar.
understand people have vacation schedules. Can we come in the week of the 21st?
That's fine.
No, I'm just looking at my calendar.
And they're looking at their calendars.
Could we do the 22nd at 2 p.m., Your Honor? And I would appear for my client.
Right, is there another day that week? Could you do the 25th or 26th?
Unfortunately, I think I'm supposed to leave the vacation on the 25th.
Okay, the 22nd and the 24th are not great dates. So,
And then they go about the business of picking their date, which we've already seen. So we've seen that before, and we are seeing it again now, and we're probably going to watch it again. I'll ask you guys if you want to watch it again as we get into this, but I think we might need to rewatch after we get into the defense's motion to dismiss. No one objects. Look, no one objects. No one seems to think that this is out of course. So the attorneys aren't acting as if this is outside of normal procedure or practice. The attorneys are acting like this is what they expected to happen. So of course, this court will be back July 22nd. Depending on what's going on with other trials, I will cover that live. If not, I will cover that on delay, but I will absolutely be covering it. But the attorneys don't act, and I'm taking my cues from them. The attorneys don't act as if this is odd to them. They act as if this is what they expected. So with all of that, we're going to go to the motion and see what the jury said, because that is really going to give us, well, a little bit of context. I can already tell you there are things in this motion that the judge is going to hate the most. This level of hyperbole is unhelpful. There are things that the judge is going to hate. So let us go to that motion first. Then we're going to go to the affidavits. Then we are going to go to the jury instruction forms if we need to, because I've got those pulled up so we can take a look at those too. For those of you in the app that are in our inside space in the app, those of you that moved over from Patreon, I had put those in there as well so you can see them. Everything in Massachusetts is made more difficult by one simple fact. They do not have digital access to documents. Someone has to be there and either get the document or like screenshot it with the or take a photo of it with their phone. It is very difficult and somewhat extraneous. And I'm like, are we really not doing anything digital? Are we really not doing anything digitally? No, they're not doing anything digitally. It is incredibly frustrating, but you have to get all these things by somebody who had to be there personally and grab them or grab a photo of them. It is incredibly frustrating. I have tried 6 different ways. There is literally no way around it. That is what this court does. So there is no other option. In other courts, it's just so much easier. In this court, is anything easy? No, apparently not. No, apparently not. It's not. All right, let us go ahead and get into this motion. We're going to go through all 10 pages of it. Will I try to go zoom through some of it? Yes, no, because there's only so much zooming we can do. It's 10 pages. This is the only thing I'm covering today, and I think you guys are here for every single syllable of it. For those of you that are going to look at this and be like, this looks a little blurry, CEG what I just said about all of these screenshots and the cell phone shots. That is part of why it is difficult. This is not the best quality, but it's readable to me. I'm going to read it, and hopefully that is enough that it is clear to you as well as we go through it. So let's add this. Emily, do we remember how to stream with documents? No. We just stream trials now. Documents. Ugh. We don't need documents. We just go to court. What are these? What is this? Back to documents just for a little bit, and then we're back to the rest of it. But yeah, the no digital docs is just so frustrating. So frustrating. All right, let's get into this. I feel like we need to bring the jury.
Bring the jury.
I feel like that's what we need, right? Like, hear ye. The defense has filed a motion. The defense is like, excuse me, there is fuckery. Can we discuss the fuckery? Can we discuss the fuckery? Let us continue on. All right. Commonwealth of Massachusetts versus Karen Reed. This was filed July 8th, right around 9 a.m. Eastern time this fine morning. Defendant Karen Reed's motion to dismiss. Now comes the defendant Karen Reed by and through undersigned counsel and hereby moves this honorable court pursuant to the 5th, 6th, and 14th Amendments of the United States Constitution and Article 12 of the Massachusetts Declaration of Rights, which is their state constitution, to dismiss counts 1 and 3 currently pending against her on the grounds that the jury reached a unanimous decision to acquit her on those charges. And alternatively, because there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Ms. Reed was not guilty, and therefore a retrial on such counts would violate the double jeopardy protections of both the federal and state constitutions. If there had been an acquittal, yes, that is true. The fight here is going to be, is there an acquittal? That is going to be the fight. And the prosecution is going to argue if it is not ticked on the jury form, then it is not an official verdict. Because this jury, the judge said it multiple times. I think this jury has been very thoughtful. I think this jury has taken their time. The judge put it on the record when we were going through the other jury questions. I think they've been incredibly thoughtful. So to say they've been incredibly thoughtful and then say they reached an acquittal, but then they didn't tick it on the jury box. Look, we're gonna pull up. Emily, were you gonna do this later? Yeah. Are you gonna do it now? Yeah. I think it's needed. We're gonna pull up the verdict form. Which verdict slip is this? This is for count 1. And this is coming from, let's see, WCVB. But this is what that looks like for count 1. Very clearly, verdict slip, not form. I call it form Californian. Verdict slip. Offense 1, murder in the second degree. Not guilty, guilty of the offense. There is a place to indicate guilt or not guilt. This is going to be a central function of the argument over this. The jury would have had to return the verdict slips. And if there is nothing written on the verdict slip, then there is an argument that they did not, in fact, reach a formal verdict. And we'll talk about that as we get through this motion to dismiss. But that's what we're going to hear being argued by the prosecution, right? The prosecution is going to say, it's not on the slip. Didn't happen. Didn't happen if it's not on the verdict slip. So they said there was no manifest necessity supporting the declaration of a mistrial. Well, if a jury can't reach a decision, a mistrial is exactly what is needed. So they then go on to say that because there was no manifest necessity supporting the declaration, I imagine there is case law that says manifest necessity, right? And they're already trying to get out ahead of case law here. Because there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Ms. Reed was not guilty, and therefore a retrial on such counts would violate the double jeopardy protections of both federal and state constitutions. And then it goes to the ancient right. The ancient right. The ancient right to a jury trial is no mere, quote, procedural formality, but rather a fundamental reservation of power to the American people. This is from Erlinger versus the United States, which is a 2024 case. Isn't it nice to see modern case law? Look at that. This is from June 21st, 2024. It goes on to say, by requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, The Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of, quote, pretend offenses and arbitrary convictions. Quoting from the Federalist Papers. But not directly from the Federalist Papers. It's like from the Federalist Papers cited from another article. But we have not gotten all the way back to the Magna Carta, but we did get back to like the Federalist Papers. So, I mean, are we back at the formation of the country? Sure. Does that seem particularly appropriate in Massachusetts? Sure. Did we get all the way to the Magna Carta? No. Did we get close to the founding? Yes, yes. Yes, yes, we did. Yes, yes, we did. Close to the founding. So Trisha Lynn said, was it the other 51? Yes, they want to know exactly which Federalist paper. This is from Federalist 83. So chat, feel free to Google who wrote Federalist 83. I don't know if Hamilton wrote Federalist 83 or not, but you know, you're welcome to figure out who wrote Federalist 83. I didn't even think to Google it. So which Federalist paper? I don't know. Let's continue. Is as prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain. It feels like it's right to drink tea. I love that you guys are like, it was actually, it's absolutely Hamilton. Absolutely Hamilton. Hamilton, according to Google. There we go. Alexander Hamilton. Sorry, what? Oh, damn it. Damn it. I'm going to okay. Look, Emily, do not derail yourself into musical theater. Bring it back. Bring it back. Bring it back. But Hamilton has now played in to our cases. Are we thrilled? Are we thrilled? Are we thrilled? Fun fact, it was published on July 5th, 9th, and 12th, 1788. There we go. 83 was written by Hamilton per Google. Chat, you are the best. I appreciate you. Because of course it was. All right, continuing on. Prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact that Parliament and the Crown had deprived them in many cases of the benefits of trial by jury. When I talk about our system being like a not what they did type of a judicial system, there's a whole lot of, but England did this, so nah. Like the founding of our judicial system, a lot of it is like, I don't like what they did. We're definitely not going to do that. So with that, the H3 Outlaw said they quoted a musical. No, they quoted the Federalist Papers. The musical was just based on Hamilton. They definitely didn't quote the musical. No, don't. My brain's trying to rabbit hole. Don't rabbit hole. No. The musical's based on the thing. They quoted the thing and we've tangented into musical theater. So, but the musical is based on the thing. They're quoting one of the things. So it goes on to say, after securing, we're back to the formations of the country though. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams, well, there's John Adams. Ding, ding, ding. Who said John Adams? We knew John Adams was coming up. We knew it was going to happen. There's also dorms at UMass named for both John Adams and John Quincy Adams. Anyway, as John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. This is a very large part of our system. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. Quote, the double jeopardy clause provides that no person shall, quote, be subject for the same offense to be twice put in jeopardy of life or limb. Also a movie. But the thing is, you can't be tried and acquitted for the same thing twice. So if she is acquitted, she cannot be retried. Does this count as an acquittal is going to be the thing? It says the clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to the embarrassment, expense, and ordeal of compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. And then the citation is omitted. Why? Do we get to the citation at the end? Maybe. It goes on to say, perhaps the most fundamental rule of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution, citing case law. The thing is, if somebody is acquitted, you can't touch this. In the infamous words of MC Hammer, we've now gotten from Hamilton to MC Hammer. Just stick with me, chat. I haven't streamed in like 5 days. We're just running the gamut. But if there is an acquittal, you cannot touch it at all. It doesn't matter what else happened, right? Acquittal, nothing else. Oh, we've gotten to Metallica. Nothing else matters. So you can't try somebody again. You can't be like, but there was an issue. The prosecution can't be like, but the judge did this and that. Does not matter. Acquittal is the is the end of the road. Boys to Men. It's also the end of the world as we know it, perhaps. I'm never going to stop. Do we need a playlist? Yes. Do we need a playlist on YouTube like music immediately? Yes. Is this what's happening today? Yes. Yes, it is. Why? Because it is. Because we have to get through this somehow. And I am so just distressed that we are here. Like I'm not distressed to be streaming. I love y'all. I am baffled as to how we ended up here, right? Here, the very day after a mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors. Put a big fucking asterisk on this, chat. Asterisks. Asterisks. Do I think it was 3 out of the 12 deliberating jurors? No. Do I think the judge is going to take issue with this level of hyperbole? Yes, but we'll get there. The attorneys have said they began receiving unsolicited communications from 3 of the 12 deliberating jurors. Does it surprise me that jurors reached out to the defense in this circumstance? No. The jurors indicated in no uncertain terms that the jury had a firm 12-0 agreement, unanimous agreement, that Miss Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the 2nd degree. Can you imagine how you would feel if you are the defense attorney or the defendant and get this information? The verdict form says not guilty, guilty. They could have just ticked the box. So why didn't they check the box? Why didn't they check the box? Like, why? Why? And we're going to talk about why that may be as we get into this. But am I frustrated by it? Yes. Because if this is true, were they confused? Were they confused that they could come back with a split verdict? And for that, I think the defense is going to be combing through the way the judge read the jury instructions. Remember, the judge re-instructed them first regarding the confusion with jury slip 2. Should we watch that? We might need to go watch that too. But the judge re-instructed them as to the verdict form on count 2. So there was some confusion there. So the jury was unanimous on 2 of the 3 charges against her, including the charge of murder in the 2nd degree. Given the central importance that acquittals have in our criminal justice system, or have had for hundreds of years, the defense respectfully submits that the jurors' unanimous agreement precludes reprosecution of Miss Reed on counts 1 and 3 and mandates dismissals of those charges. Was the jury confused that they could come back with a split verdict? Meaning they could come back with a verdict on count 1 and come back with a verdict on count 3 and not have a verdict on count 2? Could they have been confused as to that? And the information in how the judge instructed the jury is going to be critical here. And we're going to know that if the judge denies this, it's going to go up on appeal. Like, this is not going to be done quickly. Because if the judge denies this, it's going to go up on appeal, and they're going to bring in every line from the transcript that the judge said in instructing the jury to find any error or confusion. And what could happen? I mean, could, in theory, the appellate court say this might have been an acquittal? I don't know. I don't know if the appellate court had ever done that. Would that take me a little more legal research? Yes. But double jeopardy is one of those things that you do not fuck with. And depending on what happens from here, could it be a big problem? This could be a very, very, very big problem. This is not something where I'm like, okay, well, I mean, they've got to try it, right? This is not pro forma. This is not the defense just throwing anything against the wall and being like, but Your Honor, there was this and this and this. No, there is something there. Or as many in the legal profession would say, there is meat on the bones with this one. Sometimes not. This one, yes. All right. And the other thing is the jury never asked, right? Alternatively, to the extent the court believes further factual development is required, the defense respectfully requires that a post-verdict inquiry be held. And that might be the resolution here. That might be the only resolution here. We've seen it in other cases. You saw it in the Maya case, they brought a juror in. And you saw it in the Murdaugh case. They brought all the fucking jurors in. And Murdaugh, they brought all the jurors in. They're like, bring them back, bring them back. I think it's bring them out. But either way, they wanted to bring back all the jurors in Murdaugh, and they did. They made it work real easy. They brought back every single juror and questioned them. Every single one. And didn't we learn some shit about Courthouse Becky in that inquiry? So could they do that? Yes. Yes, the court could absolutely do that. But will it change anything? We're going to keep going. We'll talk about that at the end. Don't let me forget to talk about will it change anything? Because the mistrial's already been declared. So even if they question all the jurors, and even if the jurors say that there was a verdict here, could it still be entered? And that is a very unusual circumstance. So could all the jurors come back? Yes. They're asking that they allow the defense to hold an inquiry or authorize the defense to seek additional proof from the jurors. I think you should just bring them into court, right? So allow defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges against her prior to indicating to the court that they could not reach a verdict on the 3rd charge alone. And they didn't say that. They did not indicate to the court that they could not reach a verdict on the 3rd charge alone. They said charges. But count 2 had all of the lesser included crimes. So there were charges as to count 2. When we look at the verdict form for count 2, it was this and then this and then this and then this. Background. On June 9th, Ms. Reed was charged via 3 separate indictments with murder, vehicular manslaughter, and leaving the scene. The jury trial began April 16th. On June 25th, the jury began deliberations. On July 1st, when the jury was presented, no, there were other notes in there, but on July 1st, when the jury presented a note to the court, all counsel were ordered to the courtroom. We're going to go to the Jackson affidavit after this. The note was not presented to counsel for review. I want to know if the other judge or the other notes were. I see that there's a footnote. This footnote seems to be the subject of my soliloquy. I should have just read the footnote. Why don't I see where the footnote is notated to? I don't see where the footnote is notated. Oh, it's down here. It says, quote, "Well, the juror's note read by this honorable court indicated an impasse was on charges. It did not say whether the charges were those within count 2, i.e. the multiple ways to find guilt on count 2, or extended to other counts. The affidavits attached herein indicate the former, not the latter. But then why not check the box or the line or whatever? The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Yep. Once the jury was seated, the court read the note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. In context, though, this is my arguendo on the other side. The court had given the opportunity to be heard when the other notes came out, because the jury indicated this was the third time they indicated that they were unable to reach a decision. The first time there was argument, and with the argument, the judge determined to send the jury back in without giving them an Allen charge. The second time, the court heard from the attorneys and decided that it was time for the Allen charge. And then the third time, when she said the jury's at an impasse with like the sad face, you know that she's going to declare a mistrial, and none of the attorneys said anything. And the jury never asked, what if we can only reach a verdict as to some of the counts? And this is where the language of the jury instructions and that re-instruction is going to be so important. I have to remember when the re-instruction was. And I think we'll pull that up and look at it too before we finish streaming tonight. It said, in short, neither defense counsel nor the defense consented to the mistrial, and the court never ascertained from the jury whether its deadlock was in relation to one, two, or all of the charges in the indictments. Fair. The following day, on July 2nd, Attorney Jackson was contacted by a juror in this matter, Juror A, who stated, and they put she/he, I'm just going to go with they, who stated they wished to inform him of the true results of the jury deliberations. It seems by the way they worded this that this was probably via email, but we'll get there in Jackson's affidavit. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count one. Juror A was emphatic, that sounds more like a phone call, was emphatic that count one, second-degree murder, was off the table, and that all 12 jurors were in agreement that she was not guilty of such a crime. Quote, the jury also unanimously agreed that Karen Reed is not guilty of count three, leaving the scene with injury or death. Another day later, on July 3rd, stick with me here, and all the game of telephone. Attorney Yannetti was contacted by, quote, two different individuals, hereinafter informant B and informant C, who had received information from two distinct jurors, Juror B and Juror C, both of whom were part of the deliberating jury on this case. Informant B sent Attorney Yannetti, quote, a screenshot they had received from someone, hereinafter in intermediary B. Telephone. The person who contacted Yannetti got a screenshot from somebody else who had a conversation with the juror. Three different people. Juror to person to person, that person to Yannetti. Mess. That's a mess. And that is not a juror contacting the attorneys. If jurors feel strongly about this, they can contact the attorneys. Hell, they could email the court and CC the attorneys and the prosecution. This is a mess. But jurors can reach out and make this known. CC everybody. Just let everybody know. So, as to Juror B, it is Juror B to intermediary B, and then intermediary B to informant B, and then informant B to Yannetti. Miss me with three jurors talk to you on this one. So informant B sent Attorney Yannetti the screenshot from intermediary B of a text that intermediary B had received from Juror B. In the screenshot, Juror B texted the intermediary, quote, it was not guilty on second degree, and split in half for the second charge. The second charge being the DUI with all of the subcharges. I thought the prosecution didn't prove the case. No one thought she hit him on purpose, or even thought she hit him on purpose. And then it says sick. So in original, I don't understand if that's a thought she hit him on purpose or thought she hit him. I don't know. Informant C had been in contact with another individual, intermediary C, who the layers. Oh my God. So my friend's sister's cousin's coworker's brother's vet was telling him that. That's what this feels like. Okay. Informant C had been in contact with another individual, intermediary C, who's a coworker and a friend of juror C, and joined a Zoom meeting during which juror C discussed the trial. Informant C sent attorney Yannetti the below screenshots of his or her text messages with intermediary C regarding what juror C said in the Zoom meeting. So the juror said to a coworker in a Zoom meeting, whatever. And then that coworker reached out to a friend and went, girl. So I was on this Zoom meeting with one of the jurors, and this is what they said. And then that person reached out to Yannetti. The layers of hearsay here. This is not the jurors reaching out. So when the defense says 3 jurors reached out, no. 1 juror reached out. But 2 others reached out who heard from a person who heard from a juror, which seems to confirm what the juror said to Jackson. And the fact that information came from both Yannetti and Jackson is very telling to me. Because it seems that the people said similar things to 2 different attorneys in 2 different ways. But we're really at like, oh my God. So my best friend's ex-boyfriend's sister's husband's brother's surf instructor said. So the person who spoke to Yannetti heard from a friend who was on a Zoom call with a juror. This following text exchange. Intermediary C, these are people talking about what a juror said. This is not a juror saying it. Be clear. This is people talking about their interpretation of what they heard a juror say on a Zoom call. Now, if the Zoom was recorded, that's different. Intermediary C said no consideration for murder to manslaughter, started polling at 6-6, then ended deadlocked at 4 no, 8 yes. Look, this is open to interpretation. 4 no, 8 yes. Does that mean 4 no, she's not guilty, or 4 no, she is guilty? But I digress. Informant C, the one who spoke to Yannetti. Interesting. If it was no consideration for murder too, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip that was all confusing. Intermediary C, the one who was on the Zoom call, said she should have been acquitted. I agree. These aren't jurors talking. She should have been acquitted. I agree. Yes, the remaining charges were what they were hung on, and the instruction paper was very confusing. The instruction paper for count 2 was confusing, and none of the attorneys made it clear. None of them addressed it in closing. And the judge tried to re-instruct on it. Very confusing. But the other verdict forms are pretty clear. Murder, not guilty, guilty. That seems pretty clear. So getting back to this, as we get back into this motion, I need to find another document program. Okay. These are my problems for another day. Argument. The jury's unanimous conclusion that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. But does it though? Because they didn't check the box. Hope Always in the chat said, Emily, so which form did they fill out? We're gonna go to the affidavits. I don't think they filled out any of the jury forms. I think they just said we can't reach an agreement and gave back the jury forms. But we're gonna see. Argument. The jury's unanimous conclusion that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal. Quote, this is from Martinez versus Illinois, a U.S. Supreme Court case from 2014. What constitutes an acquittal is not to be controlled by, quote, the form of the action in question. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged. The mere presence or absence of check marks on a form is not dispositive. I'm sure that there is more to that case that we are going to hear about from the prosecution, but the issue is going to be they could have, and they never indicated to the court that they had any verdict at all. It says here, the attached affidavits by attorneys Jackson and Yannetti reflect statements by 3 deliberating jurors. Well, they reflect statements of 1 juror directly and 2 jurors via a friend of a friend. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations. And then we get to the Jackson affidavit. Juror A was emphatic that count 1 second-degree murder was, quote, off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. Yannetti affidavit reflecting text messages from juror B. It was not guilty on second degree. No one thought she hit him on purpose. And reflecting juror C's statement relayed by intermediary that there was no consideration for murder 2. I wonder if this is just me wondering. I just wonder if I am missing some of my sound effects. What have I done? I have messed up my sound effects because I am missing my chimes. Wait, there they are. They're just, I have done something and screwed everything up. I was trying to make space for bruh. That's what I was doing. I was making space for bruh and I moved everything. Either way, the chimes are the wrong color and that's why I couldn't find them. But it seems that at this point, they just have to bring in all of the jurors. But I wonder if with this becoming so public, will the attorneys hear from more of the jurors? Like, are we going to get a supplemental to this in a few days? Because jurors have seen this in the news and has then said, wait a second, this is or is not what happened. Can we hear the bra? I haven't put it in yet. I made space for it, but I haven't clipped it to put it in yet. So I think there's a real possibility that we learn more about this in the coming days and that more jurors will reach out to the defense because now they will see that at least one other juror has spoken directly to the attorneys and others have spoken to friends, family, coworkers, brothers, sisters, cousins, veterinarian, or whatever, and might also reach out to give their side of like, this is what happened. It's not improper for them to do that. They are allowed to speak to whoever they choose to speak to. So I just hope if they choose to do that, A, they will exercise restraint in doing that with who they choose, and B, there is nothing wrong with them CCing, sending a letter or an email to the defense attorneys and CCing the prosecution, be like, I'm just telling everybody the same stuff. They can do what they want. They're allowed to talk to who they want to talk to. They're also allowed to not talk to who they don't want to talk to. They can choose to not talk to anyone. G Mommy said, I thought Bev locked the list down. Yeah, the media can't go to the jurors. The jurors can reach out to people. The media can't reach out to them. So it's up to the jurors. They are in control of what they share or don't share, and they don't have to do anything. But it seems that they are talking. So Let us continue. I think we'll learn more in the coming days. The defense goes on to say to hold that this firm conclusion did not amount to an acquittal simply because it was not recorded in a verdict form would be to elevate the form over substance in a manner prohibited by the foregoing United States Supreme Court and Supreme Judicial Court precedents. So that's state and federal. The Supreme Court's decision in Bluford is not to the contrary. So they're distinguishing a case that probably is a problem for them because they're getting out ahead of it early. In the Bluford case, a juror reported during deliberations that the jury was unanimous against the charges of capital murder and first-degree murder, but split on manslaughter. That's a U.S. Supreme Court case. The court sent the jury back to deliberate, and when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited reprosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the juror's report. The jury deliberations had not yet concluded, and it went back to the jury room to deliberate further, it being the matter. So the matter went back to the jury room to deliberate further. Here, by contrast, the juror's statements reflect a final determination that persisted. So they're distinguishing between the Supreme Court case where a juror said, we agree, but we're hung on some, and the court said, go back and deliberate. And then they could have undone that mutual agreement, right? That unanimous agreement could have shifted, and votes shift all the time. Somebody could have been like, well, if you're going to say it that way, no. Do jurors barter? Yes. Sometimes jurors barter and are like, well, if we're going to do this on manslaughter, I'm not doing that on guilty. Do they do that? Yes, they do. Does that always feel right? Not always. But jurors negotiate. They come to acquiescence. They find ways to compromise. So when the court's like, that's not a final determination, I can understand why if they got sent back to the jury room to deliberate further. But the defense here is distinguishing it, saying, but this jury was done. This is happening after they said that they couldn't reach a conclusion on some charges. What do charges mean? So the defense goes on to distinguish that case, saying here, by contrast, the jurors' statements reflect a final determination that persisted through the end of deliberations, even assuming arguendo, and contrary to the foregoing, this court finds that a retrial would not be prohibited under Bluford. The court can and should afford broader protection under Massachusetts state law. They say, unlike the United States Constitution, the Massachusetts Declaration of Rights does not include a double jeopardy clause, but our statutory and common law have long embraced the same principles. They say reprosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was unanimously agreed. Well, how is the court supposed to know? How is the court supposed to know if the jury is unanimously agreed on any counts if nobody asks? How would you know? The double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. And that's coming from Supreme Court case from 1976. They say here, Ms. Reed did not consent to the declaration of a mistrial. I imagine when we get to the state Commonwealth's response to this, we're going to see the first jury question pulled up about them being at an impasse, because the first time Yannetti was like, look, we need to read the Allen charge and then declare a mistrial. There was argument over that early on, but it wasn't brought up. And we watched it at the beginning of the stream. It wasn't brought up again when the judge said the jury's at an impasse, bring them in. So let's see. Absent the defendant's consent, quote, state and federal double jeopardy protections bar, quote, as a general rule, retrial of a defendant whose initial trial ends without a conviction. It's pretty well settled, though, that a mistrial is declared when the jury cannot reach a verdict. And the attorneys had determined that the Allen charge was necessary. And in those conversations, with the Allen charges being necessary, there was some discussion about what would happen next. And the prosecution was really pushing for the jurors to keep deliberating, and the defense was not pushing for the jurors to keep deliberating. So what they said in those arguments is going to become very relevant to this. We're going to have to go back and look at some more stuff. This rule is rooted in the importance to the defendant of being able once and for all to conclude her confrontation with society through a verdict of a tribunal she might believe to be favorably disposed to her fate. And that comes from a Massachusetts case from 2012, citing another case from 1971. Accordingly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. That didn't happen here at all. There was no discussion. The judge just came back. Well, the jury's at an impasse, and then declared a mistrial. We knew that's what was going to happen. We're going to have to back up and go to the other jury note when she did the Allen charge. We're going to have to back up to... We got a couple things we're going to need to look at, so you're going to have to bear with me. Did I queue all those up by timestamp? No. Should I have? Maybe. Did I know I'd want to do it until I started talking it out? No. Paranormal Girl asked, Emily, will you talk about Proctor being put on unpaid leave? Yeah, at the end. As we're done with this, I'll talk about Proctor a little bit. So yes, we will definitely talk about Proctor. This is going to have to come first. Here, the defense respectfully submits that the lack of opportunity to be heard is alone dispositive. Upon receiving the jury note, the court declared a mistrial and excused the jury without consulting counsel. This action, quote, was sudden, brief, and unexpected. I'm going to have to go back and watch my stream. I think I said, well, she's going to declare a mistrial. I think she's going to declare a mistrial. The action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. That seems true. I thought they would have talked off the record. Like, I thought they were all on the same page about what was happening. It seemed that would have all happened before they called the jury in. So I'm very surprised that there was no conversation at all with counsel before the jury was brought in. Because it was brief, which is why I had assumed, this is why you can't assume, but this is why I had assumed that they had that conversation before they went back on the record, but they didn't. So I saw one question. Jury was already seated when the defense got there. They weren't. The jury had to be brought into the room. So, but it was quick. I mean, the jury was ready to come in. They say, or the defense goes on to say, the record is independently lacking on the second prong as it reflects no careful consideration of alternatives to a mistrial. I think the prosecution is going to argue that those prior conversations, when the prior notes of undeterminedness came out, I think that's when we're going to see the prosecution argue that this had been discussed. Here, there was one obvious alternative: to simply ask the jury to specify the charges on which it was deadlocked. I agree. Had the court done so, the jury articulated its verdict consistent with the statements of jurors A, B, and C, the double jeopardy implications would have been clear and decisive. And the court would have said, well, then go back and fill out the jury forms. Even when there's a hung, the court normally looks through the verdict forms and makes sure there's nothing on them that would be unclear for the appellate record. This is so frustrating. It's like the things that could just be avoided. If this is true, if other jurors come forward and say that's not accurate at all, then we're in a totally different spot. But assuming what is being said here is accurate, this could have been avoided. But other jurors could see this very differently and say, no, we initially talked about the first couple, then we never talked about it again. It goes on to say, indeed, with virtual unanimity, the cases have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict. Right. When the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury has reached agreement. Yeah. This is not strange at all. Sarah in the chat said, question, did Bev not even poll the jury in chamber? The jury was never polled. No, the jury was never polled. And that was confirmed by the clerk of court for this judge. So no, the jury was never polled, and that has been confirmed by the court. It goes on to say the Supreme Court's holding in Commonwealth versus Roth from 2002 that courts should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. That courts should not request partial verdicts on lesser included charges. As the Roth court acknowledged, inquiry concerning partial verdicts on lesser included offenses that have not been separately charged carries a significant potential for concern. Declining to require the court to consider giving the jury new options for a verdict in the form of partial verdicts on lesser included offenses where, under Arkansas law, the jury's options were limited to either convict in one of the offenses or acquit on all. Footnote 2, they're distinguishing this case. They say Massachusetts law to the contrary clearly permitted the jury to return partial verdict on some but not all counts. I agree with that. We're going to have to go to that confusing as fuck jury form. But we're not going to do that yet. I want to finish reading this. It says, such inquiry in effect implies that the jury should consider conviction on the lesser count. No similar danger is present, whereas here, the jury was asked to return 3 separate verdicts on 3 separate counts. In this circumstance where the jury reports a deadlock without specifying the counts on which it has reached an impasse, it is a straightforward, and the defense contends constitutionally required, follow-up to ask whether the deadlock relates to some as opposed to all counts. So the defense is saying that they believe it is constitutionally required to ask the jury if they are deadlocked on some or all of the counts. They say, indeed, the Supreme Judicial Court, that is Massachusetts Supreme Court, has explicitly stated where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts despite deadlock on other counts. They could have a split verdict, meaning on some, not all. Alternatively, they say the defense is at least entitled to conduct post-verdict inquiry. I mean, I think at a minimum, yes. I don't see how you could deny that. It doesn't mean it won't happen. But I don't know why it wouldn't be. So it goes on to say, undersigned counsel did not initiate the communications with jurors A, B, and C, which resulted in the disclosure of information that is memorialized in counsel's affidavits that are appended to this motion. Should this court find that further factual development is required, the defense respectfully requests that the court conduct a voir dire of the jury. Where have we seen that before? Murder. All of the murder. And or an evidentiary hearing to substantiate the existence of an acquittal. Should the court seek the affidavit of each juror, the defendants ask the court to authorize undersigned counsel to initiate contact for the sole purpose of asking each juror whether the jury had unanimously agreed that the defendant was not guilty of counts 1 and 3. The Supreme Judicial Court has held that because of the importance of the issue, juror bias is a legitimate subject for post-verdict inquiry. I don't know if this is bias, though. The problem is the case law is pretty clear on inquiring about deliberations. I don't think that counts when you inquire about the verdict, when you inquire about the split. You can't inquire about deliberations. There's lots of case law that says you can inquire about the split and that those are not the same thing. This is why it's such a mess that they weren't just polled, because now you can see the argument, right? That this is really inquiring as to their deliberations because they didn't mark it on the verdict form. So you're really asking them what happened in deliberations. And there is a huge no-fly zone over inquiring as to what jurors did in deliberations. So there is a huge potential issue in that. how do you even ask this jury post mistrial if they were unanimous? Because it's really seeking to get into their deliberations. And the case law that they're citing says that they are allowed to talk about juror bias. That's not what's happening here. It goes on to say it is similarly a fundamental tenet of our system of justice that a defendant may not be retried for a crime on which she has previously been acquitted by jury. Yes. And defense submits that post-verdict inquiry is equally warranted in the present context. There is going to be an issue, as I just said, about whether this is inquiring into the nature of their deliberations. I think there's a very strong argument that this is not inquiring into the nature of their deliberations, just inquiring, was there a vote on counts 1 and 3? And was that vote unanimous? And was that unanimous decision for guilt or not guilt? I think those 3 questions, narrowly tailored, are fine. But the amount of legal research to seemingly come to an obvious answer is not an obvious answer. This feels, to many of you, I would imagine, this feels like it should be an obvious answer, because to a lot of you, it felt when the jurors had gotten past deliberating an hour or two, like, what is the problem? Where are we confused? So for many, it might feel like this is an obvious answer. It's not. This is not going to be. So it goes on to say, just as the court in McCallop approved a question as to the existence of racial bias, questions about a matter more attenuated from the content of deliberations, whether the jury had unanimously concluded. See, that's them trying to get around this is not the content of deliberations, but it kind of is. But it kind of isn't. Whether the jury had unanimously concluded that Miss Reed was not guilty of counts 1 and 3 and did not invade the heartland of jury deliberations, but preserved the defendant's precious right to a favorable outcome of a jury trial and to the protections of the double jeopardy clause. I think in the interest of justice, there has to be more inquiry. Even if this judge denies it, the appellate court is going to have to take a very, very serious look at this, because it's difficult. Like, this is really difficult. Let's go look at those affidavits, shall we? It might feel obvious. This is not going to be an obvious, easy answer. And the prosecution is going to argue this is not a final verdict, that this is not a final determination, that they didn't mark it on the verdict forms, that the verdict forms, particularly for count 1 and 3, were clear. They clearly had a place to indicate not guilty. They had a place to indicate if there was a guilty. And because they did not so indicate, they did not reach a verdict. They did not ever indicate that they reached a verdict. And because of that, any further question, because the prosecution's going to argue like, nah. Any further question into this could be argued. I'm not saying how I feel about it. I need some case law. But the prosecution's going to argue any question into this is going to be questioning the deliberations of the jurors, which is why it was more clear-cut in Murdaugh. Did the clerk of court, did the clerk of court talk to you? Did the clerk of court persuade you? They were talking about outside influence, not what happened in the jury room. This, talking about what happened in the jury room, is stickier. It's stickier. It's not as clear. Yeah, this one's harder. This one's harder than that. And again, I need case law. Is legal research going to be needed? Yes. But are we going to be looking at this together? Yep. We're absolutely looking at it together. Let's go to Jackson's affidavit. Then we're going to go to Yannetti's affidavit. And then I think we got to go to the tape, because we have the benefit of doing that. We don't have to wait for the transcripts. We can just roll the tape, right? All right, let's go to Jackson's affidavit first. Why? Because it's the easier one to read. C. Jones said this case might have broken Emily. Yeah, well, saying clerk of court multiple times just ends up being cork of cork in my mouth. So yes, this is not easy. This is not easy stuff, and it feels like it should be easy, but legally this is difficult. And that if the jury just didn't know, that they could come back with some verdicts and not all, then retrying Karen Reed on the counts that they had been unanimous on feels like a miscarriage of justice. If they truly were confused, then yeah, that is. If there was not a final vote, then no, it gets retried. But I think we have to have those answers, right? All right. Affidavit of Alan Jackson in support of defendant's motion to dismiss. I, Alan Jackson, do declare. I do declare. Background, Pro Hoc Vice. On Tuesday, July 2nd, I was contacted by juror A, true name and identity withheld to maintain anonymity based on my conversation with juror A and that juror's description of who they are, where they were seated, and certain identifying information, name and occupation, disclosed during the voir dire process. I was able to positively identify which juror they were. Juror A told me that they were seeing inaccurate reports that the split among the jurors related to the mistrial that the court declared the day before. Right, because social media had a whole lot of thoughts, and I kept saying, don't, until there's official reports, the lawyers might not even know. So, Juror A stated that they wished to be respectful of the privacy of the deliberative process, but did wish to inform me of the true results of such process. Juror A indicated that they believe it is important to disclose such results because they believe that those results significantly impact Ms. Reed's rights. It would have been better if somebody had just asked them. I'm going to be stuck on that for the rest of this stream. Over and over and over again. Juror A told me the result of the deliberations was that the jury unanimously agreed that Karen Reed is not guilty of count 1. Juror A was emphatic that on count 1, or that count 1 was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. Juror A told me that shortly following the determination regarding count 1, the jury also unanimously agreed that Karen Reed was not guilty of count 3. So looking at those two, they're like, no, we don't think it's possible that we don't think she intended to do this or intended to hit him. So the leaving the scene doesn't fly, and the second degree doesn't fly. So you can be like, she didn't know she hit him if she hit him, and get those two right off the table. So that doesn't surprise me that they went to count 1 and then to count 3. It goes on to say on July 1st, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated the jury was at an impasse. We watched that at the beginning of stream. Once the jury was seated, the court read the jury note verbatim in open court, and without providing any opportunity for defense to be heard, the court declared a mistrial and excused the jury. Neither Ms. Reed nor her counsel consented to the entry of the mistrial. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including lesser included offenses, and on which count or counts the jury may have arrived at a verdict. Yeah, the judge didn't inquire much at all. Like, it never asked on any of the questions, is this as to one or all? Never asked. Never asked anything. Had the court so inquired, it appears clear that not guilty verdicts would have been recorded for count 1 and count 3. Ms. Reed was denied her right to receive the verdicts in her favor. The foregoing is true and correct to the best of my knowledge and belief. Dated July 3rd in Los Angeles. All right, let's go to Yannetti's. Affidavit. As I pull that up, this one's a little harder to see because it is from, it seems like it's from photo, not as clear from the other one, but at least we have them, and I am grateful for that. So This is, let me remove that just to make it easy. All right. This is the same July 8th at 9:02 or 9:07 a.m. I, David Yannetti, do hereby depose and state the following is true. I'm an attorney, yada blah, background, retained Karen Reed. On July 3rd, I received communications from two different individuals, informant B and informant C, who had received information from two distinct jurors, hereafter juror B and juror C, both of whom were part of the deliberating jury. What's interesting is that that's not exactly true. They received information from third parties who received information from two distinct jurors, indicating again that these are not the same juror. To my knowledge, informant B and informant C do not know each other. On July 3rd, informant B sent me screenshots I'm going to just go with they instead of he, she. They received from someone hereinafter intermediary B of text messages that that person had received from juror B. In that screenshot, so juror B texted friend. Friend then sent those to friend. And then that person sent them to Yannetti. Can you imagine if you're this juror being like, why the fuck are you screenshotting my texts and sending them to anybody? Like the breach of trust. Do you think you'd be mad? Would you be mad if you were the juror and you were talking to your friend and your friend screenshotted it and sent it to somebody else and then that person sent it on to the lawyers? Would you be pissed? I would be pissed. I would be pissed. Pissed. Don't screenshot texts. Oh, the way I'd be so mad. Look, if you're worried about it, tell the juror, hey, maybe you should tell the lawyer. Encourage the friend. But don't dirty ass screenshot it and send it to somebody else. It's so fucking dirty. It's just, don't do your friends dirty, man. Yeah, chat, you're like big mad. Right? Just tell the juror, hey, you should really tell the lawyer. That's it. Just positive encouragement. So on July 3rd, informant B sent me a screenshot that they had received from someone of text messages that someone had received from juror B. In that screenshot, juror B texted the following to their friend. It was not guilty on second degree and split in half for the second charge. Split in half is wild, by the way. And we haven't gotten all the way into those lesser includeds, but I think the split in half is when we get to the lesser includeds. Remember when I talked about how messy the lesser includeds were and that they weren't described by the attorneys? And that the attorneys should have gone over these in closing because chain of events was really confusing. And the jury instructions as to all of those lesser included charges were really confusing. Because in those charges, it was, did Karen Reed set up the chain of events that caused the death of John O'Keefe? So did leaving him at the party and taking off count for that? Like, I can see how you end up with a split like this when you're getting into those subsects of count 2, because A, confusing as fuck, and B, the lawyers never explained it. Okay. So the juror said to the friend that then sent the screenshot to the friend that then sent it to Yannetti, and the egg in the freaking nest, and the nest on the branch, and the branch on the tree, and the tree in the bog, and the bog way down in the valley. It was not guilty on second degree and split in half for the second charge. Do you think the prosecution is like, hey-oh? When the judge sent us back with that Hernandez thing to look at the other side, it turned into a bully match. Being on a jury is not always pleasant. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. They gave us free counseling forms when we left. Well, that's good to know. Based on the first name of juror B given to me by informant B, I believe I am able to positively identify which juror they were and confirm that they were a deliberating jury. I don't know if that's sufficient. Like, I don't know if that part is sufficient. But I think the juror that reached out to Jackson should be enough to maybe open into this and ask more questions. On July 3rd, informant C contacted me to say that they personally know juror C as they used to work together. And informant C and juror C have a mutual friend who is a current coworker and friend of juror C. Informant C told me that they had posted something about Karen Reed on Facebook on Monday, July 1st. They told me that they believe that post led to intermediary C texting them to inform them that juror C, their mutual friend, was a deliberating juror on the case. Everybody with the T. Informant C told me that they thereafter reached out to juror C via text message and discussed their experience with the juror in very general terms. They discussed what an exhausting experience it was and that the juror was relieved it was finally over. Okay, but that's not what was represented to the court. Intermediary C told informant C that juror C would be participating in a Zoom meeting with a number of friends to discuss what happened with the trial. Oh, well, that's different. Look, y'all want to know what happened? Fine, let's all get on a Zoom call with the frenzies. Let's all get on a Zoom call with all the frenzies, and I'll just tell you all the story once. What? That's wild. Today, informant C sent me 3 screenshots of text exchange that they had with intermediary C, the friend of the friend. Informant C told me that intermediary C was reporting to him or them during the exchange what juror C revealed during the Zoom meeting. Okay. Juror C is talking on a Zoom meeting. Their friend is then texting the person who told Yannetti what they're saying? Oh my God. Okay. So juror C, Zoom meeting. Friend on Zoom meeting, texting other friend. Other friend tells Yannetti. This is more gossipy than Courthouse Becky, who just said, I'm waiting on the XOXO gossip girl. Exactly. It's Allie. It's XOXO Becca Boo. So Zoom calls happening and this. Intermediary C. No consideration for murder. 2. Manslaughter started polling at 6-6, then ended at a deadlock. 4 no, 8 yes. Y'all can determine which way no means, which way yes means. No means she didn't do it. No means no yeah, but guilty. Is this a yeah, no, or a no, yeah? What? They were very consistent in the fact that they could only consider things that were admitted into evidence. Ultimately, they voted no because the cause of death was twofold of hypothermia and head injury, which they were convinced that the vehicle did not cause both. The vehicle did not cause the hypothermia. I'm convinced that the vehicle did not cause the hypothermia. It's the leaving someone in the cold that causes the hypothermia. The whole jury felt intimidated by Higgins' presence at the end. Is that the right Brian? Because Higgins wasn't in the courtroom at the end. It was Albert sitting across from them, staring at them. They're not sure what they're going to do. They're going to lay low for a couple days to see to see where it takes them. Hasn't ruled anything out. Then talk to the lawyers. The jurors all have a group text going. I imagine that the group text is gonna be real busy after all of this. And if they did indeed intend to acquit Karen Reed, then that is the result that justice demands. How we get to that result is gonna be real hard legally. Marisma said, how's many Bryans? Yes, how's many Bryans? They were confusing Higgins with Proctor. I don't know. I think they were talking. Brian Albert was the one sitting in the courtroom at the end, but we don't know. But Higgins wasn't there at the end, so we'll say. Okay, so that's the person that's on the Zoom call. The person not on the Zoom call says, "OMG, wait, no, I inserted that. OMG, interesting, interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges?" Goes back to jury verdict slip that was all confusing. Intermediary C, the person on the Zoom call, said she should have been acquitted. I agree. Yeah, the remaining charges were what they were hung on, and the instruction paper was very confusing. We'll take a look at that next. Informant C, the one who was telling Yannetti, what a great experience for them. Amazing that they let Alberta in the last day. Okay. Intermediary C, they felt very honored to be a part of it. They were a redacted physical description. Everybody else from a professional walk of life, they all got along and never heated. They agreed to disagree and respected each other. I'm heartened to hear that. I'm happy to hear that. I'm really happy to hear that they were able to respect each other, to get along, and to speak with each other with respect. Let's see. Informant C, that's the way it should be. Agreed. O knew it was an intelligent jury, or I knew it was an intelligent jury. It was a very thoughtful jury. I'm glad to hear that they, like, reasonable minds can differ. That warms my heart a little bit. The rest of this is code red level fuckery, but I'm heartened by that. They will be studying this case in law programs for years to come. How's not to investigate? Sorry, I couldn't help myself. How's not to investigate and try a case? Yeah. I don't know about law programs, but I think the investigation part, ding ding. If they all agreed to no for murder 2, they should make that clear to the DA and the court. It's basically a case of double jeopardy if she's retried on that charge. Agreed. And that's probably why the informant C went to Yannetti and was like, they had verdicts, but they didn't put them on the verdict form. But they didn't put them on the verdict form. Based on the description of juror C given to me by informant C and confirmed by the redacted content of the above text exchange, I'm able to positively identify which juror they were and confirm they were a deliberating juror signed under pains and penalties of perjury. Further affiant saith not on the 6th day of July, 2024. So Yannetti included a full play-by-play of the text exchange that was sent to him between someone listening to the juror talk on a Zoom call and their mutual friend. The Yannetti affidavit is more of a mess. A juror reaching out directly to Jackson carries more weight for me because it's easier to identify that that person is a juror. It's a little harder through an inner, like, juror to middleman to person to Yannetti. Like, there's two middles. It's a little harder to verify that that's true. I think one juror reaching out and saying we had a unanimous verdict is enough to start having these conversations and raising some questions. Can you imagine if you're these defense attorneys or this defendant going, what do you mean you had verdicts on the most consequential charges and they didn't get onto the verdict forms? Have we seen the verdict forms? No. But if they were on the verdict forms, then the court would have read them into the record and there would have been verdicts. This is an absolute mess. And because of the difficulty with parsing out how to ask jurors about deliberations and how to inquire after a mistrial's already been declared, it's going to be legally difficult. And the prosecution is going to be like, they didn't put it on the form. So I don't care what you have to say. It's not on the form. It's not a verdict. The prosecution, I imagine, is going to fight like hell. I would like to get to answers because I think justice demands answers. And this freaking case, man. Is anybody surprised that this is where we're at? Is anyone surprised that this is where we're at in this case? That even the hung jury, even they are undetermined isn't fucking clear. I'm not surprised that's where we are. Like, it just seems to track. It just seems to track. All right, let's take a look at this verdict slip for count 2. Again, this is the verdict slip for count 1. It says count 1, we, the jury, say the defendant is not guilty. Guilty. Very clear. The other verdict form, not so clear. This is all right. Hopefully that is easier for you to see. Verdict slip. Offense 2, manslaughter while operating a motor vehicle under the influence. In the above entitled case, we, the jury, say the defendant is not guilty, or guilty of the, it should say, comma, well, no, or would be improper, not guilty. Guilty of the offense as charged, manslaughter. Check one or both of the following. And then you have to determine if it's a under the influence or 0.08 or higher or both. Guilty of, this is where there should be an or. Guilty of a lesser included offense, invol. Guilty of a lesser included charge of motor vehicle homicide. And then you've got the two options for motor vehicle homicide. This isn't super clear, but not guilty is really clear. So you could NG this or be guilty of one of the lesser offenses. The thing I'm stuck on is how clear the other ones seem. But it's going to come down to how the judge described to them how they come to a verdict. So as to count 2, I can understand the confusion. I get it. If you've never looked at a verdict slip before and this is thrown at you with very complicated instructions, I get where this one's super confusing. The other ones aren't as confusing, but I just wonder if they were unclear if they could come back without coming back with charges on all of them. So I think what we should do, chat, let me know. I think what we should do is go to the other times they discussed with the attorneys. First, the discussions over the jury being at an impasse. Let's rewatch that one more time. And then we're going to go to, then we're going to go to the previous times that they had discussed the previous notes, because there were 2 notes on the first, and then there was a note the day before, like before the weekend. There was a note on the Friday before. So we're going to roll some of the tape. I promise we will talk about Proctor before we go to Q&A. How long have we been streaming? Oh, only not even 2 hours yet. Mods, thank you for rolling late. I appreciate you. We're just gonna keep rolling for a little bit until we're done, because we're not gonna stream tomorrow. So everybody who's like, thank you for a night stream, yay! And everybody's like, is there gonna be a Tuesday stream? No, otherwise there will be no podcast. So let's get into this again, and we're gonna honor NBC and cover up their logo. You know, they got the Olympic rings in there sometimes and not other times, and they get very, very fussy about it. So let's make sure that we take a look at this. And then we're going to have to go take a look at some of the other, I think some of the other options here. But this is when the court came in to say that they were at an impasse. The attorneys are all in the courtroom. The jury's not there yet. This is from the afternoon of July 1st. So
thank you. Be seated. Closing session.
22-117 Commonwealth versus Karen Reed.
All right, the jury is at an impasse. So we'll bring them in.
there's time here. There's time here. Could someone have spoken up and been like, what does that mean? What are you going to do? What's going to happen next? Yes. Is that easy here? Maybe not. So we'll see. But there is time here. It's,
You guys for the jury?
not much though. That was pretty quick. Like that was really pretty quick. Sassy Me said Bev called the mistrial rather fast and didn't poll the jury. Yep. She didn't do it in private. Nope. Bev did not poll the jury at all. The jury was not polled. The jury was not asked. The jury was not polled. Why? I don't know why.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial.
And it does seem that the only thing she has in her hands is the note from the jury. It doesn't seem that she has asked for the verdict forms or looked at the verdict forms. It doesn't seem that she has it at all. Lainey said, I thought they didn't poll because it's Massachusetts law and they can't when there's a hung jury. What I've seen is they can upon request of the attorneys. I don't think that they can't. I think they can upon request.
Well, in this case,
I don't think they
I'll be
have
in
to.
see you privately.
But she's
in
not
a few
looking
minutes,
at
so
anything.
Thank you so much for your service.
She's just looking at the note.
Please.
So, and then, excuse me, we're going to go back to this because some of you asked if Higgins was there then. I don't think so, but I don't know. I don't think so.
Thank you. Be seated. Close to the session.
I don't see him in there.
All right, I'd like to pick a status date to find out what our next move is. So I'd like to come back sometime,
All
maybe
right.
the end of July.
That's them scheduling. I'm going to try my best to scrub to the other time when the jury indicated before lunch when they got the charge earlier. Let's see. The discussion with the court about there being a potential issue. So we're going to go earlier in the day on July 1st, the first time they went on the record July 1st, and we're going to take a look at that. So we're going to zoom around a little bit on this, and then we're going to need to, well, I think I want to roll back the tape. Y'all are with me, right? I think I want to roll back the tape on one of the other moments as well when they first indicated they had an issue. Sorry for the only fan. In a stream this long, it's hard to get exactly
You are unmuted.
where you want to be.
Move back to session.
That's why I chapter my streams.
We're back on the record on the Karen Reed, Your Honor. We've got a question from the jury.
All right, so Mr. Lally, I'd like to hear from the Commonwealth first about due and thorough deliberations.
So the due and thorough deliberations is there needs to be due and thorough deliberations before you can give the charge to the jury, the Allen charge. But we are looking at the kind of last stop. This is the last stop. Okay. This is the last stop before they declare a mistrial. So this indicated to me that if the jury still came back after this without the ability to reach a verdict, that she was going to declare a mistrial. That's what I thought. So let's hear this. It indicates to me that these lawyers at this point would have seen the note. Mika said, what does verdict slips mean? It's the verdict form. So it's they call it slips, but it's what I was going over on screen a few minutes ago, count 1, count 2, count 3, it's the guilty, not guilty form. So
I'm sorry, I didn't hear the last one.
I'd like to hear from the Commonwealth first about your view on whether the jury has conducted due and thorough deliberations.
because I think this time she would have had to have shown them the
I
note.
understand that they have been at this for a while. I would submit that they have not, and I would ask the court not to make such a finding. Reasons for that, Your Honor. This jury heard, I believe, about 29 days or so of testimony, 657 different exhibits marked as evidence, 74 different witnesses who testified before them.
I apologize to everyone who's been jump scared by Lally's voice. I apologize.
And while I believe they've been out for somewhere in the vicinity of 22 or 23 hours, what I would submit to the court based on all of that, as well as the complexity of the issues presented to them, they really haven't even had 1 hour of deliberation equivalent to 1 day of testimony to each.
Half of those days, maybe a little less than half, I didn't count them. Were you talking about high top tables at the waterfall and if there was snow? So do I think they need at least an hour of deliberation for all of those days? And some of those witnesses were lovely. I thought the Kolakithases were delightful to hear their testimony. But does the jury need an hour to deliberate whether they were sitting at a high top fucking table for the 10,000th time? No.
Of the days of testimony that they've heard.
No.
So while they have been at it for a while, I would submit that based on the evidence and testimony and witnesses and the complexity of issues in this case, I would submit that they have not done a thorough deliberation up to this point.
Not too long. Mallory.
Mr. Yannetti?
Our view is that it's time for Tui Rodriguez, Your Honor. They've come back now twice indicating essentially that they're hopelessly deadlocked. The content of this latest message is that they have been over all the evidence.
So he's got the message at this point. So this is him having that he has the contents of the message. Do I keep playing with my layout? I'm sorry, I do. But he has the content of that message.
Previous message said they did an exhaustive review. This time they said that they have fundamental disagreements about what the evidence means. And it's a matter of opinion. It's not a matter of lack of understanding.
Right.
This court, when you sent the jury out, encouraged them not to take a straw vote, encouraged them to go over all the evidence in a very methodical manner. I think all indications are that they've done that. And this is what Tui Rodriguez is for. We asked the court to get it.
Yeah. All right. I think this has been an extraordinary jury. I've never seen a note like this reporting to be in an impasse. I do find that they're now, with the additional time that they went out without coming back Friday saying that they were deadlocked, is due and thorough deliberation. So I'm going to give Tui Rodriguez. So are they ready to come in, Jody?
And that's when she gives the much stronger instruction, encouraging them to go back and figure it out. So they're going to bring the jury in. We're going to go and listen to that and see if there's anything in there that is confusing.
So why don't I take a recess?
The court's like, and I'm out. Here, we're gonna zoom. The court's like, and I'm out until we're ready. Bring them back when they're, bring them back. All right. At least we stopped it before the OnlyFan. So let's see. Oh, always an issue with zooming.
All right. So, jurors, I am in receipt of your note.
She sounds so dysfunctional. I'm in receipt of your note.
Judge Cannoni, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. So, Mr. Foreman and members of the jury, I have an instruction for you. Our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking in all cases, absolute certainty cannot be attained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of the other jurors. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be
somebody else
submitted
isn't
to
gonna
12
fix it.
persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment, then the defendant is entitled to the benefit of that doubt and must be found not guilty on that indictment. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their own minds is a reasonable one, if it makes no impression upon the minds of the other jurors who are equally honest and equally intelligent, who have heard the same evidence with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. At the same time, those jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury.
Right.
They should ask themselves whether they should distrust the weight or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. I will now ask you, Mr. Foreman, and members of the jury to return to your deliberations with these instructions in mind. And as with my final instructions and the supplemental instructions I sent in, I will send in a copy of this charge as well. All right, so may that be marked, Madam Clerk.
So they have it.
Please.
And
All right, so thank you. We'll send you folks.
so they're going to send the jury out. I don't know if they
Please.
talk to the lawyers anymore in this. I want to see if they say anything else to the lawyers, because the lawyers were very clear that it was time for this instruction, but they never talked about if they can't come back, if a mistrial is what needs to happen. They don't mention that at all here. And so the defense just asked for that instruction. That instruction was given and read, and the jurors were sent out. But it doesn't say charge or charges. It says charge each time.
You are muted. Goodbye.
And then the court goes off the record, or at least off the public record. So on Friday, that's it. The defense was it was never discussed on the record, and now we're at the point of a mistrial. It's implied when they get to the point that the court is saying, I'm going to give this instruction now. But knowing that the defense and presumably the prosecution wasn't shown that last note, only told the jury was at an impasse, they were brought out, it was mistried, and then off and away you go. Could that create a problem? Yes, especially if the jury is saying, no, we reached some verdicts, just not all. The verdict forms are going to have to be reviewed. The verdict forms should be in the court's possession. The defense should have access to see those. It's not brought up in their motion at all, which indicates to me that there's nothing on the verdict forms to indicate that they were thinking one thing or another. So the judge here doesn't mention anything about charge versus charges. And then the only question remaining is, in the jury instructions as a whole, was it confusing? So with all of that, at least one juror directly to Alan Jackson indicated here. Let's try to do a summary of this real quick before we start talking about Proctor and answering questions. With everything we've seen from the defense motion, it's clear that one juror reached out directly to Alan Jackson and said, no, we were unanimous that Karen Reed was not guilty on count 1 and count 3. That's the second-degree murder and the leaving the scene of an accident causing death, and that they were hung, and it seems from later discussion, evenly divided, or at the end, 8-4, that they were stuck on count 2. Remember, count 2 has the DUI, but also all of the lesser includeds. And some of those lesser included that chain of event language. So if the jury was looking at, did this cause the chain of events, then I can understand where in those lesser includeds they might have gotten stuck in the weeds, where some people are like, yes, and some people were like, no. So with all of that, the judge never polled the jury, which is why the defense is now making a motion to dismiss count 1 and 3, saying that Karen Reed cannot be retried on those due to double jeopardy. There's also 2 other jurors that are brought up in an affidavit by Yannetti and in the motion, but those jurors did not speak to the attorneys directly. Those jurors spoke to other individuals directly, and then those other individuals spoke to their friends, and then those friends spoke to Yannetti. So when we get to the other 2 jurors, those jurors did not seek out the attorneys directly. They were speaking to others, and they weren't speaking to the people that told the lawyers. They spoke to intermediaries. Those intermediaries spoke to third parties. Those third parties spoke to Yannetti. And that gets a little bit more messy when we're looking at, is this really what the jurors said? Is this what they intended? A juror reaching out directly to the attorney is much more consequential to me than jurors telling their friends, friends telling a friend, and then that person telling an attorney. That becomes a difficult game of telephone. But I think there is a big issue here. The legal issue is also going to be, can this be undone? Can it be inquired about later? Is inquiring about the jury's vote in the verdict in the jury room, when they didn't put it on the verdict form, is that inquiring about the jury deliberations, which the court cannot by law do? The court cannot inquire about the deliberative process. Or is this, aside from that, where you can ask about the vote and you can ask about the jury and poll them? I think there is going to be some fighting over whether or not the jury can be asked about this. But I wonder if more jurors come forward, if this will become more clear. And I wonder if now that this has made the news and now that this is publicly known, if more jurors will come forward. I mean, what we've seemed to hear from a Zoom call from a friend to a friend is that the jurors are all in a group text. And so I'm sure they are discussing this. Could it be that the jury initially said, yeah, we're all agreed, and never came back to those counts, and that's why they didn't put anything on the verdict form? There's a lot of possibilities here, but it's going to be real sticky to ask about those possibilities without getting into the nature and discussions that happened in the jury room, which the court cannot inquire into. It's why it was a little clearer in Murdaugh. They were asking about whether or not a third party had spoken to the juror, not what the jurors decided amongst themselves. Starting to talk about what the jurors are deciding amongst themselves is a legally difficult thing. And can I see this going up on appeal? Yeah. Is that more likely what will probably happen here? Yeah. At this point, I think the appellate court is ultimately going to have to decide whether this jury can be polled. What's the practical result of that? Well, if the judge denies this, if the judge denies the motion to dismiss, if the judge denies any further inquiry, then that motion will be appealed, and the appellate court can review the existing case law and can narrow out an exception or can say no. But while that's up on appeal, I think that they can't go to trial again, because if Karen Reed is entitled to an acquittal on 2 of the counts, you cannot retry her on those counts. And I think it will stall this case until that appeal comes back. And I think if this needs to go up on appeal, that's what should happen. What's going to happen in the meantime? A whole lot, because we're already seeing Proctor being relieved from duty and now being relieved without pay. We know that there's an ongoing federal investigation. So what happens next? Well, we're going to have to wait and see. But what we need to do is talk about Proctor, and we need to get to questions. So this is not going to be easily decided. And though it feels in the guts, like it should be clear cut, right? Like if the jury truly decided this, it's a miscarriage of justice for her not to get that acquittal, if that's what they decided. If that's not what they decided, then everything goes forward like normal. But don't we have to know that? And knowing that is going to be difficult. So how much legal research is needed on this? Lots of legal research. Let's talk about Proctor, and then let's talk about Proctor, and then let's get to all of your questions. You guys have great questions. So let's do all of that. Emily, let's get to Proctor and then answer questions. But I wanted to hold on to some of these questions real quick because I saw one and I couldn't go back and grab it. Hold on. Amora said, what was the outcome of Proctor's hearing? We're going to get into that now. Jolene said, Emily, did the jury have an opinion? Did the jury have the option to claim not guilty on 2 and say they are hung on the other? Yes, the jury can do that. I don't know if the jury knew they could do that. So let's get to what's going on with Michael Proctor real quick. And this is coming to us from, where is my news? Where is my news article? This is coming to us from Boston 10 or NBC 10 Boston. Let's see if I can do it. Let's try to do it this way. Emily, are you changing around your screen setups? Yeah. Why? Why not? We can do it. We can do it this way. It'll be fine. That's not fine. That's fine. Oh, we're so close, yet so far away. Hold on. If I do it. No, I can't scooch. I need to scooch myself. Let me just move myself over real quick. Hold on. Let me just move me over. Let's just like that. Perfect. Look at us. We've got it handled. All right. This is coming from NBC Boston 10. Trooper Proctor, lead investigator in Karen Reed case, suspended without pay. Oh, I can. Oh, that makes my life so much easier. I just wish I could zhuzh it. I wish I could just, no. I wish I could zhuzh it. I'll zhuzh me down a little bit so I don't cover the side. And I will zhuzh me down a little so I can scroll up, but I wanted to make the font bigger. So thank you for letting me just mess with my layout with, reckless abandon. Because we can. Massachusetts State Trooper Michael Proctor, lead investigator in the Karen Reed murder case, has been suspended without pay after a duty status hearing Monday. Remember, especially with government jobs, due process is a huge part of the thing. So there has to be hearings. There has to be process. You are entitled to a lawyer. You are entitled to process. So first he was relieved of duty. Now he has been suspended without pay. So are they stair-stepping towards getting him getting terminated? It seems that way to me, that this is part of the process that he is entitled to. It says interim police superintendent Colonel John Maughan accepted the recommendation from the duty status hearing board, a body of 3 commissioned officers who heard evidence in the matter, according to a police representative. Proctor had publicly admitted to making unprofessional and regrettable comments about Karen Reed during the investigation into the death of her boyfriend, Boston police officer John O'Keefe. The investigation led to Reed being charged with second-degree murder, manslaughter, and leaving the scene of a personal injury and death, which she denies. 2 updates came Monday in the Karen Reed case as her attorneys filed a motion to dismiss of second-degree murder and leaving the scene, and the Massachusetts State Police suspended Trooper Michael Proctor without pay. So, last week, after a 9-week trial, a mistrial was declared. Her lawyers claimed on Monday that the jury had been ready to acquit her on 2 of the charges, including murder. Proctor had already been relieved of duty and had his police-issued cruiser, gun, and gear taken away. So he had to know that this was coming. This hearing is part of the due process he is entitled to before he is terminated. But they had already taken away his car and his gun. The fact that he, text messages aside, the fact that he also admitted to drinking and then driving his police cruiser, like there is so much here. It's wild to me that this didn't happen before the trial. But okay. Proctor made about $102,000 a year in base salary and over $35,000 in other pay the last 2 years, including to publicly available payroll. That would be like overtime and stuff like that. The internal affairs investigation into Proctor remained ongoing, a state police spokesperson said Monday. So today, they said that it remained ongoing while announcing Proctor's suspension. So he has not been terminated. He is now suspended without pay. I imagine termination is the next thing that's going to happen, but we'll see. The department will issue a finding on each allegation, sustained, not sustained, exonerated, or unfounded, and relay the results to the state post-commission, which keeps police disciplinary records. In such investigations, if charges are found by investigators to be warranted, they are adjudicated by a state police trial board. Let's see. A protest was scheduled to take place Monday afternoon outside the State Police Troop H barracks in South Boston, where Proctor had been reassigned from the Norfolk County DA's office. The transfer did not make him eligible to work in Troop H. While Proctor testified about I lost that sentence completely. While Proctor testified during Reed's trial that he referred to the woman as a, quote, whack job, he texted his sister, hopefully she kills herself. He insisted the comments had no bearing on the integrity of the investigation. Sure, Jan. Testimony from Massachusetts State Police Trooper Michael Proctor could have a ripple effect for other criminal cases. Yeah, especially ones he was involved in. Proctor's comments prompted widespread outrage. The governor called the comments terrible. When the governor of the state for which you are a state trooper is appalled by your behavior because she has heard you call a female suspect a "see you next Tuesday," I would suspect that he is aware that his job is short-lived at this point, because when the mayor is mad, not the mayor, the governor, when the governor is mad, we've gone above the mayor. When the governor is mad and you are state police, I imagine the governor is going to be like, what the fuck is happening? Last week, the governor of Massachusetts, no, that's not Mowen. Hold on. Between Mora and Mowen, my brain got confused. Last week, Mowen, the acting commissioner, condemned the comments and said they do not reflect the agency. I think the only way to make that clear to the people of the state of Massachusetts is to terminate him. Let me know what you think. Quote, I have been very clear, and I want to be very clear, this conduct in any way, shape, or form in the Massachusetts State Police will not be tolerated. There were 2 major developments in the Karen Reed case Monday. We saw that already. Let's see. And that is the end of this in reader mode. So, Proctor has now formally been suspended without pay. That is one more step towards him being terminated, though he was the lead investigator in another high-profile case in Massachusetts. So this is going to be a mess for that case. it is going to potentially be a mess for any retrial of Karen Reed, though it seems that any retrial of Karen Reed is probably going to take a minute because this issue with the jury has to be sorted. Because if there is a double jeopardy issue, it has to be sorted, right? So it seems that they are going through the process of terminating Michael Proctor and going through all the hearings that he is entitled to and all the due process that he is entitled to so that it doesn't get unwound down the road. Sorry, the hair and the in-ears are fighting. But I think that's the ultimate. I think that's the ultimate thing. G. Lynn asked a great question in the chat, which reminds me that we are going to need to go to questions. Hold on, let me grab that. Ryan Blackhawk, I agree. And we haven't covered that case yet, though I intend to down the road. Oh, I totally lost the chat. I was trying to grab it. And it is, there are a lot of people in here. So with, over 20,000 of y'all, I'm sorry. I was trying to grab the chat. But what it had said was, before I get to questions, what it said was, can the governor yeet the charges? Essentially, no. There is separation of powers. If Karen Reed were ever convicted of something, the governor could then, why are words so hard tonight? The governor could overturn that conviction. But the governor can't tell someone not to prosecute because of the separation of powers. So we will see. I mean, pardon, thank you. Why was that so hard for me? That was just, my brain literally stopped. Thank you, chat. Chat is bae, and I appreciate you. Thank you, Michael. So the governor can pardon that, but can the governor really say you can't try this? No. It's not a good idea at this point. Look, the prosecution came out so fast with we're retrying this case, and more has become a huge issue. So let me see. Tina, I see your question in the chat. I was trying to grab it, but with 20,000 people, it jumped. Ask Emily about the judge impounding the juror names for 10 days. We'll get to the juror names. Do not worry. And impounding is just what putting something under seal means. So in Massachusetts, when we're talking about court, impound means under seal. So the jurors' names are under seal, which means the attorneys know them, but the media can't get them. And it's not for 10 days. The juror list is impounded because it was a hung jury. So the attorneys would know who the jurors are from voir dire and from the initial list, but the list is impounded. Normally it's for a period of time so that the media can get to it after a while. In this case, that's not going to happen. That doesn't really forestall the attorneys, though. But the attorneys did ask for permission to talk to the jurors and inquire more. All right, let's get to questions. You've got questions. I've got questions. Oh my God, it's already 9:30. Okay. I'm sure some of you are quite tired, but let's go. All right, we're going to get to questions. If I do not get to all of them, I apologize. I'm going to try to get to as many as I can. To all of our members, thank you. To everyone who gifted memberships, thank you. It is an incredible way to give back to the community. It supports me as a creator. I think it is wonderful that memberships can be gifted to everyone who got them. If you are new members, welcome. There was a Lawnerd After Dark episode in those members only lives, amongst other things. So to everyone who gifted memberships, it is thank you. Thank you for the support, and thank you for giving back into the community. It's really an incredibly generous and kind thing, and I very much appreciate that and appreciate all of you. So thank you. Thank you. Thank you. Big Murph said we still live here. I mean, War Critic asked, why can't a mistrial be undone if the judge was wrong or biased? So, if the judge made wrong rulings, the result is that a new trial is granted. So With a mistrial, the result is that a new trial is granted. So there's not a lot that can be done with a mistrial because the result of most appellate things is a new trial. So with like the what case did we just talk about? Weinstein, where the convictions were overturned. The result is okay, but you get a new trial. That doesn't really help here because the result is already new trial. Katie said there's no chat like a Law and Order chat. No chat like a Law and Order chat. Because a Law and Order chat don't stop. I agree with you. Good to see you all. Good to see you all saying hello to each other before I got on to stream. Michael said, how is the Proctor decision going to affect the Walsh case? Is there much hope in that case? I don't know when the Walsh case is set for trial. It's been loosely on my radar as it winds towards trial. I was intending to kind of hop into it. Another case with those Google searches. I was intending to look at the Walsh case when we get closer to trial. So I don't know. I don't know how much there is there. Annie, at least Gerson. I've pronounced that 19 ways and probably all of them are wrong. Said, praying I go into labor tonight, need Law and Order vibes. Good luck. Happy laboring. Hope everyone is happy and healthy and that it goes smoothly and well. For all of you asking about the Walsh case, it is another case out of Massachusetts. It is a high profile case. I have not covered it. I will get it wrong. We will get to it another time, but it is another high profile case with some very, very sussy Google searches. Kim said 25 months with you guys. It's been a ride. I mean, an emergency ride on a Monday night tonight. So for all of you that have said you've missed daily trial streaming, don't worry. I think we're going to get into opening statements Wednesday or Thursday for Baldwin. So we're going to have at least a couple more weeks of live trial. So don't worry. And then we've got to get back to like Corey Richards and stuff. Like there's so much stuff. For those asking about Sarah Boone's not impacted by this at all. It's also on my radar. I was waiting till Sarah Boone sorted out her lawyer situation. We're definitely not jumping in now. Lucas said it's the trial that keeps on giving. Sometimes I wish there would just be results and then we would just be done. But that's not going to happen. Shirley, missed you. Hope you got some rest. I did, and I've been resting the voice, which needs a rest. Tammy said Donna Adelson at the end of September. Yep. Right now, Don Adelson seems on track for the end of September. We'll be covering that too. Rachel said, yay for being a Law and Order for a year. Congratulations. Thank you guys, all of you, for saying hello, Law and Orders. I appreciate all of you. Jamie said, has this ever happened before in previous trials? I'm sure it has. Is there case law they can refer them to help? The defense didn't bring up any case law that was directly on point. This is not going to be easy. Has it probably happened before? I don't know. If it's not a high profile case, I don't know if the jury would even think to reach out. But again, it's odd. It's just odd to not poll. Whitney said, Emily is never late. I've been also trying to give a little room for our notifications. It seemed that they worked really well tonight. Carolyn, who is Donna Adelson? I've covered it on the channel. That's a long and winding road. Will Baldwin be in court? Yes, he was in court today for motions. So yes, Baldwin will be in court. The real question for me is, will Baldwin testify? And also, I'm ready for another 2 days of half cock, all cock, full cock, no cock, super cock. I'm like, we're ready for all of the gun experts. It's going to be wild. It's going to be wild. So let's see what else. Weird Pisces said, Friday I had my C-section and we'll have my baby. Congratulations. And yay. It's a strange process. The C-section, you're just like, I'm here too. It was an odd thing. So enjoy and congratulations, and heal and recover well. Elizabeth said, thank you for creating an amazing, generous community. Thank you all for being part of it. I can only ask. Y'all are just like, yes, we want that too. So I appreciate it. Christy R said, no Wi-Fi or power due to Barrel all day. Just as went out to hook up the generator so I could watch EDB power came on. It's like they knew I needed EDB. Hopefully y'all are well and safe and have power and can stay cool. The thing about hurricanes are crazy. So be well, be safe. Sonia said from Middle Tennessee, drinking Dr. Pepper Zero. Dr. Pepper is so beloved here in Tennessee. I don't think I was aware of how beloved, but very beloved. K-Rab said, thank you for taking the time to cover with us. We appreciate you. I appreciate you guys too. I wanted to talk about it. I just couldn't sit down and record about Baldwin for the podcast tonight and then do this tomorrow. I was like, I can't switch paths. My brain already wants to talk about this. There's no derailing the ADHD. Caitlin said, my mom, my sister, and I love watching you. My first live I've been able to catch. Yay. Can you give a shout out to my mom, Mary, and sister, Nicole? Caitlin and her mom, Mary, and her sister, Nicole. Hey, we've given a shout out. So yes, we can. I love seeing you guys chat with family in the chat. Not only is Caitlin saying hi to family in the chat, but Sudoku Slayer said hi to my mom, Susie, who is watching for the first time. I can't tell you, even though when we're in trial, I don't always get to pull them up. I love seeing you guys communicate with family and friends in the chat when you're saying hi to each other. It's really a ton of fun. Beth said in New York for Go Fest this past weekend, it looked so good with a Sprite recovering my voice from seeing a live taping of The Daily Show. I understand recovering voice. Mine is better, but not all the way there. Creekside said, holy guacamole, the jury really did reach a verdict. Did the jury really reach a verdict on their bingo card? Not me. Not me. But doesn't it make sense? Nikki, I feel like you're in my house. I definitely had to go to the bathroom before streaming, but that's not all of where I was. I had kid stuff that we needed to do. What the actual fuck with this case, said Courtney. Isn't it fitting? Like, doesn't it make more sense that the jury was clear on counts 1 and 3 and not clear on count 2? Like, logically to me, that just makes sense to me. Like, all of that just makes sense to me. That just makes sense to me. So, yes. Motion to start out in code red. Music to my soul, I considered it. I don't know if it's fuckery. I think that there's confusion, and I don't want to impugn the jury because I don't think the jury is up to bullshit. I honestly think that they are well-meaning and confused. I really don't think that the jury meant to cause problems. So I considered the code red to start with. And then I went, you know what? It can't be code red because the jury isn't up to fuckery. I think they just didn't know what they didn't know. And they're probably really pissed. I'd be pissed if I was like, wait a second, you mean we could have just done that on the verdict forms and come back with this one? And we didn't know that. And we didn't even know to ask that. Because how do you know to ask if you don't know? I would be pissed. Excuse me. I'd be pissed. McRae H said this feels like what should have happened, but why did they not mention any of this in the jury notes talking about being deadlocked? That I don't know. And maybe we'll find out in the days and weeks to come. LB said, EDB, I happily put aside tonight's grad school work for this. Who needs an MBA when I can get a master's in EDB law? Do both. Hopefully you can do both and put me on in the background. It was so funny because at VidCon, I talked to a lot of YouTube folks. And one of the things a couple of them brought to my attention, they're like, you have a lot of people that watch you that have YouTube Premium. Like, what's that about? And I was like, oh, really? Like an outsized amount for other channels of YouTube Premium. I'm like, I can tell you exactly what that's about. People want to listen in the background. They're like, oh. I'm like, can we make that a member benefit? They're like, okay, no promises on anything. I'm like, but wouldn't that be cool? But I was like immediately watching the background. I said, my channel is so different than others. This isn't short form content. People want to listen in the background. So listen in the background becomes a huge benefit. Just like not getting slow moded is a huge benefit. Just like not exactly Valkyrie Art's like, because fuck ads. Also not having ads in the background is huge. So it was really funny because people were like, wait, what? So let's see. God knew. Julie, I would double check that you are on the correct account. I would double check that you're on the correct account. I see that you're asking about being a member because it's not showing on this account, but make sure you're on the correct account first. So anyway, hopefully that helps. Jenny said, God knew I needed some EDB law nerd time today. So thankful for you and our people. I'm thankful for our people too. Our chat is amazing. We continue to confound people. They're like, this chat is amazing. So Brandy said, I remember the emergency rides during Tati. I know we are long overdue for an update on that. Nishay, I feel you on that. Casey Cat said, don't you want to know what was discussed in the jury room with Bev and the jurors after the mistrial? I mean, she said, I'll be right back. Who knows? It might have just been, you don't have to talk to the media. This is how we're protecting your information. It might have just simply been that. What was on those verdict forms? That's what I want to know. I want to know if there was anything on the verdict forms when she got them back from the jurors. Because normally you see the judge say, okay, do you have the verdict forms? Can you give them to me? And then the judge looks to see, because if anything's marked on them and they're not signed, then the judge will inquire. But there was just nothing. It was like, I got your note. We're done. And Proctor was suspended without pay today at his hearing. Yep. Proctor has to know the writings on the wall to the end of his career. Like, he has to. MD said 100% got premium so I could watch in the background, right? EDB is my ride along through the day, throughout the day. That's what I'm here for. Mojo Agogo said, isn't this the outcome exactly what the defense argued was confusing about the jury form? I don't think so. They were arguing, could the jury get stuck on count 2? But they weren't talking about the verdict forms for count 1 and 3, because those verdict forms weren't confusing. They were pretty straightforward. But they were worried about how would the jury indicate they were hung on the verdict form for count 2. It was part of it. Yep. So let's see. Great end to a Monday. Shout out to Miranda and David, please. Shout out from David B to Miranda and David. Ty said, I'm playing Stardew Valley while watching. My kiddo, as I was playing Animal Crossing, was like, you should play Stardew Valley with me. I was like, And now I can't start a new game because we have a new trial. But then there will be gaming. It's like we have a trial, and then we have August, and then in September it's Adelson, and then there will be more. So we're going to do, this year is going to be trial heavy. Sam said, every time I think we've plumbed the depths of fuckery with this case, we seem to find more. Yep. When does Toddy go to trial? I need to take another look because I do not know off the top of my head. Tim said, can't stress how important I think channels like this are for our system. We don't get enough effective education on the legal system. Tim, I appreciate you. It's why I started my channel, and it's why I like covering live trials, because I can't make up a hypothetical with all of this. Like, I can't hypothetical this shit. There is no hypothetical that would ever come to my fucking mind that would be like, and then the jury was hung, and then they weren't pulled, and then they were like, oh, but we reached verdicts. It would never cross my mind. Like, it would never cross my mind. So by watching trials, we learn. And we learn about different jurisdictions, and we learn about, I don't know, the hear ye of it all. I still think every jurisdiction should adopt South Carolina's further affiant saith not that's at the end of their sworn affidavits. I think that's amazing. I think it's great. I also love the hear ye's. I think the hear ye's are a great way to pull the courtroom together at the beginning of the day. The way I'm trying to convince Judge Abby's bailiff to just start court with hear ye. I don't think I've been successful in that yet, but I'm gonna just keep watching. Gotta keep trying. Desiree said, needed this stream today. My grandpa had pacemaker surgery today, so I was waiting most of the day for updates. That is, waiting on medical updates is the most stressful. Boffle Waffle said, Boone is pro se and set for October. That case pro se is going to be interesting, isn't it? Well, hopefully we'll be done with Adelson by then. Candace says, do you know where the FBI stands in their investigation? No, but we are supposed to have time to look at the letters that were sent back and forth from the federal investigation now that this trial is done. So hopefully we'll get there. Hopefully we'll get there. Any updates on Corey Richens? I haven't seen that she has new lawyers yet, but her last lawyers asked to be yeeted. So I am waiting to see when they reset the preliminary hearing date for. Heather says you need to look into the Massachusetts State Police CDL scandal in Staunton, Massachusetts, next to Canton. The shit doesn't end. Sometimes when there is shit, it does not. Susie Q said just moved and I'm unpacking. You're like, we've moved to New Mexico. Let's go. No, I think you mean literally moved and am unpacking. Well, you were welcome. I'm glad to be here tonight. The Lawnards sent out the bat signal. So it's been a minute since we've done an emergency ride. Huge thank you to our mods and to my producer, Megalina. Tim said my longest membership in the YouTube law space. You've been a member for 19 months. Thank you, Tim. Boop the Snoot Tiffany and others have asked if I watched Paul's interview. Well, Paul's weird interview. I have not watched Paul's interview. I have been doing family stuff and recovery stuff because the travel, the 9 weeks of trial, the travel, and the VidCon all took it out of me. We'll talk more about VidCon. On our members only live stream. Be happy for me. All youngest get married on 6/6. That yay, E Warner. Hopefully I interpreted that correctly. Karen asked, what about an update on the Tic Tac psychic? The court found liability, but we haven't gone back because she's trying to yeet the court and that's not going to work. So there's not much of substance there other than the court found liability. And then we covered that a while back. During this trial, we did an extra stream. So it's up there. Let's see. Lola said I have my second oncology appointment tomorrow, so I'm happy to have this and Runkle as distractions tonight. I love you, Lawnards. Those can be hard nights sleep. Try to get some rest. But how do you feel about Comes Now? I think it needs to be a movie series, a book series by Beaver Moon Publishing. We love announcing it loud and proud. I'm gonna stop there before I digress. Before I digress anymore into that. Some guy said, have been watching since the OG Tati, she who must not be named lawsuit. I miss the We Ride streams. Thank you for all you do. You're welcome. And I've been trying to establish some balance in my life, but sometimes we just have to fucking ride. And as the app, as the team and the app work together, it'll be a little easier to say we ride. But I also am very mindful, Lawnards, after we've come off a long trial, the mods are tired. The Lawnards are tired. Everyone is tired. So I don't want to just be like, mount up and let's go, unless it's really needed. Tonight was really needed. Good to see you, Octo. This case has zero chill. Yes, it does. Absolutely zero chill. What do you think of Proctor's being suspended without pay? Nana Banana 9, I think it is the first step to him eventually getting fired. Well, I guess the reassignment was the first step. Taking his gun is a big indication, but I think the text messages, amongst other behavior, probably violate a whole bunch of rules. Lindsay said, question, do we get the old Ride at Dawn merch back? We'll see. We'll see how much we need to ride to see if it's needed. Emily, do you think it was a strategy by the defense to not ask the judge to pull the jury and say they didn't ask because the judge didn't ask? No, I don't think they could have ever anticipated this happened. And that happened quick. So I just don't know. I don't know what they were thinking. So I just don't know. War Critic said, Emily, it is upsetting to hear 8 jurors believe Karen was guilty in any shape or form. What do you think? I think it's unclear whether 4 no, 8 yes indicates guilt or not guilt. I think there's a lot of room to interpret it in different ways. I also think that when we look at all the different charges, the lesser included charges, there is room for conversation with the jurors about her leaving him there. I think it's clear that she left him there. So I think there's room for conversation. I think those jury instructions were really confusing. And all they did was read the instructions, including that chain of events instruction. So I think that was to the lesser includeds. And I think when the lesser includeds are looked at without any explanation, I can understand where we got that. Chrissy said, did someone confirm 8 guilty, 4 not guilty? No, it's not. I think there's room for interpretation both ways on that. And that's why I did not say I thought it was one way or the other. I think there's room for interpretation as to which way that went. That one chick said this case gets crazier and crazier. Yes. Loch Nessie is singing Regulators. Yeah. It was a clear, dark night, a clear, bright moon. Warren G was on the road, rise, something. I've lost the last one, but yes. But this case is wild. This is wild. Where can we send suggestions for the app? Neen, Mac, we are help at can always help if you need help with the app. Suggestions for the app will come through our member spaces first once we make sure that the app notifications are being facilitated the way I anticipate them to be facilitated. Katie says not traveling. Also, no pressure. You were the best. Not traveling, not traveling. Might never travel again. Dr. B was like, hey, so next summer, I'm like, you're adorable. Next summer, we're going to be in trial for 3 months. He's like, why is it always summer? Because it was Depp v. Heard. He's like, why is it always summer? Why is it always summer? I'm like, I don't know. Let's start planning what we're going to do for fall break in October. It's going to be great. And he's like, But I haven't told him I need to look at the Adelson dates to make sure that fall break and Adelson doesn't overlap. Don't tell Dr. B. He's going to be like, are we ever doing anything ever again? Yes. So said, didn't we ride on Christmas Eve one time? We did. It's been a minute since we've had such an emergency. We did. When documents dropped on Christmas Eve, I was like, are you joking? And then I was also like, let's just do it now. Chef Cindy Anderson, love EDB almost as much as I love DMB. I hear you. I don't love me as much as I love DMB, I don't think. Thanks for all you do. You've helped me through losing my dad. I'm sorry for the loss of your dad, and I'm forever grateful. That's what this community is here for. I also love DMB. So I feel you. Look, DMB is magic. I'm just a girl on the internet who talks about law and shit. Clever Word Mash says, live EDB on my birthday. How lucky am I? Happy birthday. And I hope it's a good one. Girl, I just noticed your beautiful arms. So glad to be here with you tonight. Anytime. I mean, they're colorful. So we're happy for that. Multiple birthdays in the chat. So SugarMag78, happy birthday. Doesn't the judge usually read the note first? Blake, normally the judge will read the note and show the attorneys the note, and then they'll discuss the note, and then they'll discuss what they're going to do, and then they'll bring the jury in. That's normally what happens. And that seemed to be what happened with the first 2 notes in this case. And then the third note, the judge was like, the jury's at an impasse, bring them in, and then declared a mistrial, and then out we went. So Kelly said the judge was rude and would not let the defense ask any questions. She snubbed Karen Reed when they were arguing the verdict form. The judge definitely had her moments. So the interview Paul did was super weird. I haven't seen it yet. Did they turn in a verdict form? I don't know. I don't know if the judge ever asked for the verdict forms back. I don't know. Lynn said, thanks for covering this tonight. How did we get here? Jurors were like, wait a second. Honestly, how we got here tonight seems to be social media. Jurors saw people reporting a split on social media, and the jurors were like, timeout, that's not accurate. And then we're like, no, we actually had decided on these things. And then the lawyers were like, the what? I'm sorry, the what did you say? Wild stuff. Thank you for the gifted memberships. Thank you, Lindsay, for the gifted memberships. I'm going to try to speed run some questions because tomorrow we've got to record the podcast and then we've got to start the Baldwin trial. Sue said Bev and the Commonwealth employees at all levels made conscious efforts to cover corruption with incompetence and accidents at the risk of ridicule and shame. They shock us with the audacious absurdity. Is this evidence of desperation? Is what evidence of desperation? I don't know. I think this truly is confusion. But I'm going to wait and see more. So we'll see. Shirley said, I watched Crash Daddy tonight. You were the star of the show. Crash Daddy was one of the stars of this trial for sure. Can there be issues if the jurors felt bullied? Not if they felt bullied by each other. That's part of deliberations. I mean, the jurors saying deliberations were rigorous is getting too much into deliberations. So that's difficult. Victor said, is the court still in 1776? Possibly, with the we're not going to give you air conditioning. That's the building's issue, but with the no availability to get documents online, it's a problem. Katie said, I did not have taking the red eye on EDB air on my schedule for the day. Neither did I. But here we are nonetheless. Yay us. Look, I think all of us just, deserves a little round of applause. Where'd my round of applause go? It's here somewhere. Maybe it's not. Maybe I'm confused. No. Well, I mean, that's close enough. It's close enough. Did I remove the applause? I might have. Did I get halfway through redoing my soundboard and then forget to finish? It seems like I did. So I also have to finish that before we start Baldwin. Arthur said, quick, get the Magna Carta. We need to quote English law that never actually became law. I mean, lawyers everywhere. Sue said, this I answered. So I think the jury was confused on this. I would like to know Judge Bev's practice for other cases. Does this judge never poll? Does Judge Bev never poll? I would like to know that. KKW said Hamilton was not on my bingo card. Mine neither, but wasn't it a delight? Casey Cat said not being on the slip. Not being on the slip is on the foreperson if they voted and found not guilty on counts 1 and 3, correct? Yes, he was the one who filled it out. The foreperson should fill it out, which is why we've got to consider, was there confusion when the jurors were like, okay, we're not considering these two. Let's talk about the one in the middle. And when they couldn't reach the one in the middle, they're like, okay, well, if we can't reach a verdict, then we haven't reached a verdict, and maybe didn't understand that the not guilty also counts as verdicts and that those needed to be reached. So it's a tough thing. And I think there was confusion. And if I was the jury, I would be frustrated. It's hard to know what you're supposed to do or not do or ask or not ask. And so I feel for them. Brentwood Chick, thank you for the gifted memberships. I'm thoroughly enjoying full ADHD mode. Oh, all night tonight. The lyric card just happened in full time. Just in real time, nonstop. Stacy Scott said they've documented seating at the basketball game and the entire layout of the high tops and who drank what, but neglected to document a verdict. I don't think they were told clearly. So, jury room, the land of confusion. Phil Collins. Do you think the judge will dismiss this immediately? No. Jessica Pinky Mingo, I don't think it's that easy. And why didn't the judge ask to clarify? I don't know. It seems to not be this judge's habit and practice. I did not see the Paul O'Keefe interview. Spicy Golden Retriever Energy. Such a good screen name. Can the jury mark only certain slips without coming to an agreement on all charges? Yes. If so, should the court have instructed that? It should be in the jury instructions. Maybe they thought they had to all or nothing. Yes, we would have to go back to all 40 whatever pages of the jury instructions, and I will take a look. But yes, each slip is independent and each slip has a guilty, not guilty. So could this sway the prosecutor not to retry? I don't know. I think it might encourage the prosecutor to retry if they're like, hell, we were 6-6, let's go. But if Karen Reed is entitled to an acquittal on 2 of the counts, then they should only retry on the DUI. Just a face, said Emily. I wish I didn't need you to explain all this to me, but I'm thankful for your voice. You are a scholar. I don't know about that. I just try to explain. You are a scholar and a gentle person. Just a face, thank you. And also, I'm here to explain it's what I enjoy doing. Mama Pink said only Magna Carta was issued on June 1215 and was the first document to be put into writing. The principle that the king and his government was not above the law. I'm also ADHD and I follow you at 1.75 speed. Mama Pinks, that's incredibly impressive because I think I talk fairly fast. Could jurors be intimidated by Albert Power? I don't know if any of the jurors are in Canton, so I don't know. Apple jam peanut butter. My best friend's sister's boyfriend's brother's girlfriend heard from this guy who knows a kid who's going with the girl who overheard a juror at 31 Flavors last night. I guess it's pretty serious. Exactly. That's exactly where we're at. Jacqueline said, I'm dying here with your telephone renditions. I mean, I can't go Lady Gaga telephone. It's way above my registrar, but that's where we're at. Frankie's mommy 143 said, how many people broke out into REO Speedwagon? Heard it from a friend who heard it from a friend who. Yes, exactly. Question, would it be worth retrying on just the DUI? No illusions. I imagine if they were going to go with just the DUI, maybe they could come up with a resolution, but I don't know about this. Ruth said, was 1 hour closing appropriate for 30 days of trial? I don't know how the judge came to 1 hour. And I don't know if the judge asked the attorneys, can you do it in an hour? And they said yes or no, but it was quick. They should have used the jury instructions. I think they had time to do that. So Caroline said, could the judge have asked if they had a verdict on any charges? Yes, the judge could have. And if yes, send them back to fill out the form. Yes, the judge could have. Why didn't the judge? I don't know. I can't explain this, Judge. I can't. It defies my brain. Why did the judge do this? I don't know. Audit the audit said, love your channel. Thank you. You're so good at making legal jargon digestible. It's how I digest it in my brain too. I know how difficult that can be. Cheers. Thank you. I appreciate it. It is not always easy, but you throw in enough yeets and we understand. If the jurors are polled later, could their certainty of the agreements on the verdict of a charge change? This is part of the problem, Slayer. Could it be that the jurors didn't think they were taking an official vote? Could it have been like, yeah, this is off the table, let's focus on this, and they never came back to it, so they don't really have a conclusion? All of those things are possible, and that's hard. Sean C. Kate said, question, isn't it the foreman who fills out the jury form? Yes. What if the foreman chose not to fill out the form because they couldn't agree on all the charges? That's possible. But then polling the jury would generally fix that question and be like, oh, you all agree? Go back and fill it out. I just don't know if it can be unwound. And it's tough. It's tough. So I think, again, this is not an easy question, though it should be, because the potential for issues is huge here. But if a few of the jurors are like, I thought that was a final vote, and some of the jurors are like, I didn't think that was a final vote, then you're now really inquiring as to the provenance of jury deliberations, and that is something the judge could not inquire into, which means this is all difficult. Heather said, with the judge adding the lesser charges, the law did that. So the law, by function of law, the lessers are included. Could it cause potential issues since those are seemingly where the confusion lies? Yes and no, because those are operation of law, lesser included. Janice said, got into Cornell Law for my master's in legal studies. I seem to have yeeted my applause sound, so congratulations, Janice. I'm very happy for you. Wait, hold on. We've got chimes. What else do we have? Do we have anything else? Crickets aren't appropriate.
Oh my God, Janice, congratulations! That's very exciting. I love to celebrate. Whoop, whoop. The chat is celebrating with you, so watch the chat. They're very excited.
I can see them being excited from here. Is not polling the jury the judge's normal behavior? I don't know. It would be nice to know if anybody who's practiced in that courtroom speaks about it. I will go look for it, but I don't know. Gigi said, I'm confused on what will happen next. Gigi, I hope I can help. the prosecution will respond. The judge will either address this at a hearing or address it at the July 22nd hearing, or we'll set it for another hearing, or we'll ask for more briefing. So what will happen from here? More process. But now we're in motion practice. Motion to dismiss. We're going to get a reply to the motion, and then we're going to get we're going to get the motion, which we have. We're going to get an opposition. Then we're going to get a reply. Then there will be a hearing. From there, they will have to figure out what to do. Is it possible that more jurors will have more to say between now and then? Yes, it is possible. Yes, it is possible. Do you think this will make the prosecution think twice about retrying the case? I think there's a lot of things, Jen, that should make them think that. I just don't know if they will. I don't know if they are inclined. Do we suspect fuckery here from the judge? I don't know if this is the judge's normal practice. If this is what the judge always does, then it's just what the judge always does, and it's a problem. If this is not what the judge always does, then I have other questions. So I don't know. This is not a judge I know. So we've only seen her in this trial, and this is a problem. Also, if we don't poll the juries unless somebody asks, then the defense should have been ready to ask. That's something that if that is the issue, judges don't poll the jury unless they ask. Then the defense should have been ready to be like, excuse me, Your Honor, are we polling the jury? When the judge said, okay, bring them in, Your Honor, may we be heard briefly? Can the jury be polled? They should have been ready with that if they knew that. But it is absolutely a mess. Loch Nessie, good to see you. Let's see. Laura said, I used to work in the clerk's office. Can confirm. I would say Kirk office. It's hard to say clerk of court and not say clerk of clerk or clerk of court. The more you say clerk of court, the more difficult it is. Judy, you got this. Good to see you. 2 years and still learning the local quirks in court. The local quirks are interesting. It's what I very much enjoy. This feels very California raisinish. Heard it through the grapevine. There's no way I can do that justice. Michaela asked, are we having a live stream tomorrow? No live stream tomorrow. This was tomorrow's live stream. Tomorrow podcast. So can we get Justice Toll sent up to Massachusetts for this hearing? Yes, pro hoc vice. Can we pro hoc vice and a judge? Just airdrop Justice Toll. Energizer said, good day from the land down under. You're going to get the whole chat singing. I come from a land down under. Can the governor just flip a table and say enough? What? A la Teresa Giudice. Just 19 times. And say no more trials. No. Also, small favor, can I get a shout out to my beautiful wife, Victoria? Energizer 916's beautiful wife, Victoria. Hello. Thanks. Also, you're a legend. Thanks. Yay. We try. Gina Justice said, if Bev has to testify or it gets us to a new judge, it's worth it. I don't think Bev is going to have to testify, but could this go up on appeal? Yes. Peter at Lawyer said polling the jury is not allowed in Massachusetts. If polling the jury is not allowed, because I thought the sides could request it. If polling the jury is not allowed, then polling the jury after a mistrial has been declared is going to have to just go up on appeal. So I will go take a look. It was my understanding that the jurors could ask, or that the parties could ask, but we're going to have to look. I mean, the thing is, I don't practice in Massachusetts. So I am going off of what I have read and understood. It's much easier for attorneys that practice, though Peter doesn't practice in Massachusetts either. I can't believe it's not allowed. I imagine it's not practice and you have to ask. So KL said, Laura, said parties can ask. That was my understanding too. So that is my understanding too. So with all of that, y'all, podcast recording tomorrow. Julia asked with or without behind the scenes. With behind the scenes, is my intention. I don't know what time yet because I have things I need to prep for tomorrow's podcast and I have kiddo stuff I need to take care of. So it will be later in the day, but I will keep you guys posted on when the podcast recording will be, which means the podcast will probably go out late, but you never know. because our, editors and producers are magic. And sometimes things happen. But my intention is that it will be a little late so people don't have to work late because we're already working late tonight. So that is what that is. I saw somebody else say in the chat, lawyers, Peter from Lawyer said judges may poll, not judges shall poll, which means they don't have to, but they can, and the lawyers can ask. So we will see. Incredible. Anyway, so what time on Wednesday for Baldwin? Unknown. It just depends on how far they get with jury selection. So that is going to be in the app. The Law & Order app will keep you in the loop. So once I know, and that should be at the end of the day tomorrow, we should know what we're looking at for Wednesday, or if jury selection is going to go over. If they don't get a full jury tomorrow, jury selection might go into Wednesday, and we'll kind of work from there. So if you want to stay in the loop, Law & Order app, we are working. Octo and Chris have been working to make sure these app notifications go out. So we will make sure that you are in the loop as soon as I know. That one won't be as time sensitive because it'll be a heads up at the end of the night tomorrow. Will jury selection be streamed? It normally isn't. Sometimes it's audio only. So we will see tomorrow. I don't know if it will be. I am not going to stream it because I'm going to be prepping the podcast to make sure you all have a background on Baldwin. And I want to go through all the rulings on the, today on the motions in limine. And then I'm going to do a brief road so far of that before we start opening statements. So we all have a set foundation, but the lawyers have been spicy with each other since we've kicked this off, and at least we'll understand. Do you know what the judge did today? Okay, hold on, just give me three seconds. Okay. Today, the judge told the lawyers, and we're going to get into this on the podcast. So if you're like, I heard this before, yeah, it's because we're gossiping at the end of stream. Okay, so today, the judge is like, no objections. You have to come up to sidebar for every objection. And the defense attorneys were like, what? The defense attorneys were so mad. They were so mad. They were like, what do you mean? What do you mean? What do you mean? What do you mean? What do you mean we have to come to sidebar for every single objection? The judge isn't going to let them do objection grounds at all. Nothing. They have to go to sidebar. They have to go to sidebar. She's so mad about what happened during the Hannah trial. She's like, no, that she's not even going to get to, I'm going to take your coffee away. Straight up, no objection, no grounds. And the defense is like, can we please just say like, objection sidebar or objection hearsay or objection relevance? And the judge was like, no. And the defense is like, what? He's like, this is going to slow down everything. And the judge is like, until you prove to me that you can behave yourselves, this is the ruling. This is my court. I'm in charge. Don't worry. We're going to talk about it in the podcast, and I'm going to play the clip of it in their podcast. But the defense did not like the result. Like, they fucked around and found out in real time. And the judge was just like, nope. And the defense was like, shut up, really? Like, no way. Shut up, really? So we're going to talk about that. But the judge is not having it. It's going to be hard for us because it's so much easier when we hear the grounds. It's so much easier when we hear the grounds. We're not going to hear anything. They're just going to go sidebar. So the judge is just like, the judge turned this trial around before it even started. So are the lawyers going to get spicy? Yes. 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 Yes, it is. So Phoenix said they have to earn it. Yeah, with good behavior. I don't know if she's going to keep a star chart or what, but the judge is going to make them earn back the right to act like adults in court. It's going to be wild. So we are going to be talking all about Baldwin in the podcast with an overview of everything that happened. And then before we start closing arguments, I'm going to stream probably 30 minutes, maybe a little bit more before closing arguments are scheduled to start. So I can give kind of a run up to what's happening with what was ruled on in the motions in limine, why we're not going to see objections. So I'll give a little bit of a summary or a road so far as we get into opening. So I'm not going to start right before opening statements start. I'll give us a little leeway, which is great because they're in mountain time. So if they start at if they start at, 9 a.m., it's 10 a.m. my time. So I meant opening. I meant opening statements. Did I say closing? Yes. Before opening. So we're on Mountain Time for that. So we are 1 hour behind Central, 1 hour ahead of Pacific. And what is that? 3 hours behind? No, 2 hours behind. I don't know. For Eastern, I think that's, I don't know, 3 hours behind. I don't know. We're in Mountain Time. So 1 hour behind, 1 hour behind Central, 1 hour ahead of Pacific, 2 hours behind Eastern. I don't know. So that's what we're doing. But I will let you guys know when we are streaming for opening and when that's going to be. I'll keep you updated in the app and in the community tab here tomorrow of when I expect that to be. We'll see how they get with jury selection. They're going in rounds of 79. So we'll see how well they do. I imagine it's not going to go as fast because Baldwin is Baldwin and people have strong Baldwin feelings. But then again, the Paltrow jury got selected pretty quickly. So we'll see if they get the jury done in a day. We have opening on Wednesday. So we will see what happens. ET is 1 hour ahead of CT, right? So ET will be 2 hours off of Mountain. Central's 1 hour off of Mountain. Pacific's 1 hour behind Mountain. So time is fake. I finally watched Bridgerton too. I hope you enjoyed it. I finally caught up on Bridgerton and I enjoyed it. So we will see. Do I have time to get my nails done Wednesday? Laura, I hope so. I don't know what time court's going to be starting. I think they're going to be starting around 9. I don't remember what they did for Hannah, but it's going to be around the same time they did for Hannah. So probably around 10 a.m. my time. So we'll see. But Baldwin is Baldwin, so the jurors might have strong feelings, and we're on a second trial. We already had the Gutierrez trial, so depending on how much local attention Gutierrez got, it might impact jury selection some just because Gutierrez was public, and we're going to see a lot of the same witnesses here. So we'll see. Will it take a day? I don't know. Will it take more than a day? I don't know. Either way, I'm going to keep you up to date in the app, and that was the longest goodbye ever. So with that long goodbye, law nerds, I appreciate you. Oh, Christina, I didn't see it before. I don't know if the super chat didn't go through. I didn't see it. Did you see Weinberg being added as a defense lawyer? Do you know him? Also, what do you think of Bev's timing of the motion today, and what is impoundment? Impoundment, I know we talked about earlier. Impoundment is sealed. The judge sealed the jury list. We knew that last week that was going to happen. I don't know if it was just formalized on the docket today, but we knew that was going to happen. Do I know of Weinberg? No. Will I look? Yes. I'm not surprised the defense added another lawyer to deal with some of these issues that might be appellate trial lawyers, and appellate lawyers are not always the same breed, and appellate lawyers will see things that the trial lawyers might not have. So I wouldn't be surprised if that was somebody to look at the appeals aspect of all of this, because this is probably going to have to go up on appeal to deal with. So with all of that, law nerds, thank you for being here. Thank you for being a law nerd. I appreciate you. It's good to see you. I'm always happy to see you in the chat. I look forward to seeing you in the chat this week for another trial. I look forward to seeing you on the podcast. Members, I'll keep you posted. And with that, good night, take care, and I'll see you soon. Bye. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.